For pronouncement of judgment. Criminal Reference Law of 2021.
No.
Copy.
In the instant case, we are of the view that the question of stopping the proceedings under section 258 of the CRPC would not even arise when cognizance itself was yet to be taken. The learned magistrate would be well within the provisions of law to pass an order of either dismissal of the case or rejection thereof, as the same was not initiated in the manner prescribed under the law. Under the Act of 1989, reference stands answered, matter is remanded back.
Criminal Appeal Z 56 of 2022.
Doesn't.
In view of the aforesaid facts and circumstances, we have the view that the conclusion arrived at by the learned so-and-so in convicting and sentencing the appellant is based on cogent materials and do not call for any interference. Appeal stands dismissed. We record our appreciation for the learned amicus.
Criminal Appeal Z 85 of 2022.
The aforesaid discussion and the materials on record would, in our considered opinion, not be sufficient to come to the conclusion of the involvement of the appellant and none else in the offense in question. That being the position, the benefit of doubt has to go to the appellant as the material before the court would not conclusively lead to holding the appellant guilty of the offense. Appeal stands allowed. Appellant is acquitted. We end our appreciation.
मैं प्लीज अलर्ट
Just हमारी pencil लग जाना है क्या? Pencil लग जाना है दोनों से क्या? Right. Yes.
मैं प्लीज अलर्ट your lordship I beg to mention item number 9 of today's daily list your lordship 9 kindly the matter be listed after a week your lord
And it's for orders, isn't it?
yes your lordship
Why? What orders?
there is an IF for bail your lordship as Begum she is not well your lordship
Okay. On a prayer. Yes, madam. Next week. On a prayer made on behalf of the appellant. List after a week. Item 9.
oblige
May I please, your lordship? Your lordship, like to mention item number 17, Lord.
17.
Lord.
Yes.
Kindly pass over for the day, lordship.
I for what?
Bail, lordship.
We'll have it next week. Same order. 17. Next week.
Oblige.
কিন্তু পানী নাই পানী চাব লাগে না
Lordship. Item number 16, Lordship, the learned,
yes
item number 16, Lordship.
Yes.
From the respondent side,
yes
the engaged counsel, the arguing counsel is out of station, Lordship, and leave note is also given. So this matter may be fixed, adjourned for a week, Lordship.
from the other side.
Yes, Lordship.
What is the matter
Yes.
about appeal? You are for the informant. You are for the
From
informant,
the respondent side, Lordship.
not respondent. Say informant. Respondent.
Yes,
There are
Lord-
two respondents.
yes,
You should know
Lordship.
which respondent.
Yes, two.
On a prayer made on behalf of the respondent number 2. Matter is adjourned to be listed after a week.
Macho.
Please, Your Lordship. My lord, item number 15,
Yes.
service report upon respondent number 2 is still to receive, Lordship.
Matter under POXO.
Pokso, Lord.
We'll let the matter reach. We'll see the office note.
May the Lordship, my lord, I beg to mention item number 7, my lord, I am for the informant, respondent number 2, my lord. We have not received the copy of the memo of appeal and I am, my lord, till date, my lord.
Paper book has been prepared. What memo of appeal is required now?
We have not received any, my lord.
Paper book, have you received the paper book?
No, my lord.
We have received. He's for respondent number 2, my lord.
I'm informant, my
We
lord.
are for the appellant.
Okay, madam, you have received the paper book.
Second, my lord.
Yes.
Seven, Lordship.
I will-
Gulab Hussain.
Right.
Paper book
It-
furnished to you? No.
No, Lordship.
It may be in the office. Paper book are there.
We have received, my lord. My lord, we have received the paper.
Oh. Though paper book has been prepared. Sri N.K. Das,
My lord.
Learned Counsel for the respondent number 2, has informed that he is yet to be served with a copy. First up. You have
Not,
Miss Begum, the learned APP, also submits that copy of the paper book has not been furnished to them. Para? Registry to verify, on office to verify, and furnish copies of the paper book to the remaining council.
My lord.
List after 2 weeks.
My lord. Yes, Lord.
In date,
2 weeks.
All right. Yes, Lord.
My lordship, I would like to mention that we have filed an IA under 389 in a criminal appeal. So the matter may be kindly listed in detail.
Where did you file?
Sorry?
It's a new matter. Is it a new filing?
already filed.
Pending matter? When was it last listed?
We have filed, but it is not listed.
When did you file?
4/11/2020,
Under what section?
389.
Is it possible now?
What?
After the notification, again, 389.
File to substitute the temporary file for state.
Aren't you required to give the new sections after the High Court notification?
E-filing any that was mentioned in Nahogono.
You
and
take
file-
instructions, come back later. Okay. Yes, next.
Item 1.
This is the appeal against judgment order dated 12/9/2024, caused by the Lamet System Judge Krishna Sahil, conflicting the accused appellant under section 302, awarding life imprisonment and a fine of rupees 10,000
Okay.
till the
Oh,
court.
okay.
Appeal may be admitted for hearing.
K. Sharma, huh? Admit, call for the record. 302 আছে, but there is an informant. Madam, for respondent number 1 state, steps for service of notice upon the respondent number 2 in the manner prescribed, steps within 2 days. List after 6 weeks along with service. Huh? Same.
We are filing a IA application for the.
We'll
immediate
issue
harm
notice.
After receival of LCR.
We'll issue notice. Huh? I had to notice the steps. Okay.
3302.
Item two,
May it please your lordships.
Yes.
Lordship, it's a contested matter. And the opinion is at page 33. It starts from page 33 to.
We had issued notice.
Yes, Lordship, in last.
Yes. Yes, Charlie?
Lordship, I am appearing for response number 3. Mr. Council appearing for FT is on Lake in court number 6.
Wait for a while. This is a,
Moreover, LCR, Lordship,
LCR is not-
LCR is not there as per the cause list, Lordship.
Maybe call for a Lordship.
that we had called for the.
Yes,
Yes,
already
it's-
called for on 30th October.
They are challenging the
Yes.
inquiry report, your Lordship. The LCR may be required. That is going to be annexed to the.
Yes, sir. Miss H. Betala, learned counsel for the petitioner by referring to the office note dated 21, has submitted that though wide order dated 30/10/2024 notice was issued and records were called for. The records have not been received. Para. Office note dated 21/11/2024. Read with 2/11/2024 have been perused. Para. Registry to give immediate reminder for transmitting the LCR to the concerned Foreigners Tribunal number 6, Borpeta. List after after 3 weeks with report on receipt of LCR.
In the meantime, I may be protected.
Let it come.
item three,
Lordship, it's an ex parte order. Order is at page Lordship 23.
Yes, what has happened? Records have come.
Yes, Lordship.
Yes,
Uh,
we can have it tomorrow. If the records have come, we can have it for disposal
Yes, Lordship.
tomorrow or day after.
Yes,
When-
day after.
Day after tomorrow, okay?
Yes, Lordship.
Pursuant to the order dated 30/10/2024, the records have been received. Para, on the prayer made on behalf of Sri Payang,
Yes.
learned standing council, Home Department, matter is adjourned to be listed on Wednesday. Date.
item four,
In this case, Lordship, LCR is there.
They will have similar plan, I don't know.
Wednesday.
Yes,
Wednesday, same. Go to disposal, will go see what on. Madam, you take a note, this LCR have come, so we may go for some length of hearing, so come prepared.
I'll indicate your.
One more, 2 more.
item five,
5 LCR is not there.
Let
Lordship.
of this.
না 825 একে প্রথম টো নিস না অফিস নোট টু বদলিব না অফিস নোট 211 রেডি 2111 একে আগৰ 211 2111 আছিল লেকি হ্যাঁ এক্সাক্ট হ্যাঁ আৰু এটো এফটি হেৰি এফটি নাম্বাৰ what এফটি বাস্কা ম্যাডাম Madam Betala, which FT?
Yes, Lordship,
Baksa or what?
it's Paksa.
Is there a number?
No, Lordship.
Only one, there is only one.
Yes, sir.
এটা আগতে বৰপেটা number 6 আছিল না, এইটো বাক্সা হ'ব।
Item 6.
Receive your order.
Hmm.
Maybe
This-
next week, Lordship, because 4 cases are fixed on.
Let's have it on Wednesday. Let's see if it's required.
Yes,
We'll
sir.
adjourn
Yes, Lordship.
it Wednesday, huh?
Much.
Bless.
Item 8.
May I pick?
Yes.
Doctor, in this case, we have received paper book. Doctor, may pick for hearing.
Yes, madam, receive
Right.
paper book.
Item 8.
Anything?
It may be in the, it is not with us right now, so paper book.
Paper book
Will
has been prepared and furnished to the parties.
Hello.
Para. List for hearing in its turn.
Doctor, may pick the date, doctor. For hearing. doctor.
List for hearing in the first week of
Lot.
January
Lot.
2025.
Deeply obliged.
Item 10.
Paper book prepared.
Not prepared.
Prepared.
Oh, prepared, yeah.
Lot here. Paper book received, Lord. But in this case, Lord, service is awaited, Lord.
Boxo.
Doctor, Lord. Office note of December 2023, Lord. Thereafter, no office note is there, Lord.
Yes, madam, you have to get the report on service of notice, POXO matter.
Police station.
Set for hearing. What's the para? As agreed to by the learned counsel for the parties. List for hearing when?
50 or not?
5th of what?
Oh, December.
5th of December.
January. Or January after
January,
vacation.
no, after vacation.
In the first week of January
Blessed.
2025. First week of January.
Okay.
Today it's wrongly come for orders. It
Yes.
have come for hearing. actually.
Okay.
Item 13.
Media I never did it. I'll get it.
Item 14. Yes, what is this?
My Lord, in this case, already we have taken two peace step matter. Thereafter, this honorable court has given the direct
POXO matter.
matter.
Copy not served to us, Lordship. I have
Today,
said him several times.
Why don't you, why
Yes,
are you
ma'am.
delaying the matter? Okay.
Yes, my Lord, today I will have the copy.
Yeah, it appears.
Lord, we have taken steps long back, Lordship. Non-APS was respondent number
POXO
two.
matter.
Yes, Lordship.
Sunny do Lordship, we have got the service report. Oh.
Timing will not be possible. Who is the council? We'll have it on Wednesday. Wednesday. 27. On a prayer made on behalf of the appellant, matter is adjourned to be listed on 27th. Why is it listed today? Okay, Wednesday we'll check.
Obliged.
You should check the file.
Item 20.
In this case, medical report was called for in the Central Jail Guwahati. I have received the report. This convict is suffering from pulmonary tuberculosis. The treatment has been given to him. Complaints of cough, weakness. He has been admitted in LGB Chase Hospital.
You are under
treatment.
Lordship, may I pray, Lordship? Until the decision, final hearing, final decision of the appeal, Lordship, he may be released on temporary bail, Lordship,
No,
so
no.
that
He is getting treatment.
even then, Lordship, it's better here, at least let him survive for some time so that he
No,
get
had
ready
your
for
case,
the
had your
for
case
the-
been,
for
ve-
the-
had
for
your
the-
case been very
to
serious,
the sentence, Lordship.
had the case been
Yes,
of serious nature.
it is very serious.
It's not serious. Some medicines have been given, cough, weakness. Nothing more than that.
And it's a recent report of 1811.
Yes,
I
it-
don't think it's
If it is that to that effect, Lordship may give a detailed observation that his health not seems to be very serious. And
Why detailed observation? What is
Lordship,
there, whatever is
because-
there will
because
record that.
Yes, Lordship, I have been instructed that he is very serious, Lordship. His condition has been
Regard-
deteriorating.
Ms. T. Soam, learned counsel for the applicant. Also heard Ms. B. Bhia, learned APP Assam. Full stop. You file objections.
Papali will
Yes,
file the
objection.
objection, yes.
Objections filed.
We have filed our objection.
Is it on record? No, it's not on record. Get your objection on record.
Yeah, right.
Have you filed actually, madam?
Lordship, we have filed. But
Hmm? You think you didn't file glass? No objection. Oh, no objection. It is on 20 date. Over to first. No written objection. Full date to 2011. When did you file?
copies served on 1811.
18.
For 2011, you please check, okay?
I'll check.
Pursuant to the order dated 13/11/2024, Ms. B. Bhia Learned APP Assam has obtained instructions, including the medical report. She has also informed that objections have been filed. Objection has been filed on 18/11/2024. Full stop. Para. Office note, however, does not reflect the same, and rather has depicted that objections have not been filed. Oh, absolutely. Oh, file. Is there. Sorry, is there. Expeditions hearing on. Okay. Expeditions hearing. Early hearing. Oh, your objections you have filed in the bail.
Hello.
It's there. This is, we are considering the early hearing petition.
My lord. Oh, here I have not filed,
No, early hearing, you have obtained the report, that will be enough, I think.
my lord.
But since will are the paper book to be prepared?
No shit.
Pardon. Ms. T. Sum, learned counsel for the applicant who has filed this application for early hearing on the ground of medical urgency. Para. This court wide order dated 13/11/2024 had directed the learned APP Assam to obtain instructions. Full stop, para. Ms. B. Bhuiyan, the learned APP, has obtained instructions including the medical report of the applicant, which has been placed before us in original. Full stop. Peruse the same. Full stop. From the aforesaid report, the condition of the petitioner does not appear to be of serious nature. Para, be that as it may, we have seen that records were called for while admitting the appeal, which are yet to be received. Para, registry to issue reminders for transmission of the record so that the appeal can be heard expeditiously. I stand disposed of.
I'm deeply offended.
It was early hearing or right, huh?
Lordship, date of hearing be fixed after the receipt of
No, no.
notice here.
So as to fix. We have not fixed the date of hearing.
Item 27, supply list.
Advocates?
Yes,
Lordship, they're buying us on 6, Lordship. Better maybe fix that's 2
27.
on legs,
on left.
paper book prepared.
Yes, sir.
Why is it for listed today?
I is, I think, pending. You have
I is
given our
pending.
objections.
You want to press the IA?
Yes, sir.
Madam Brown here for whom?
For the respondent number, your lordship.
Legal aid counsel.
Yes, your lordship, but I have received a copy of the application.
Which one? The IA?
Yeah,
If you are pressing the IA, you serve a copy upon her and we'll fix it day after tomorrow maybe. You have filed objection.
I'm not aware of. We have given objection. No, I think we have also not given.
Then no, you have given objection.
Oh, yes.
Madam, you should know the records. Where we said no objections filed. There is an objection which has been filed on 18 September 2024
Objection is filed.
by your colleague, Madam Begum has filed.
Oh,
Oh, yes, objection is filed.
Doesn't matter.
think of it.
Oh.
Yes.
You'd like to file objection?
Your lordship, first, I may receive.
No,
a
that is
copy.
it. You'd like to file objections. You take instructions. Are you in touch with your clients as a legal aid counsel?
No, your lordship.
You go through the IA?
Yes, sir.
Miss M.K. Brown.
Yes.
M.K. Brown, learned legal aid counsel, appearing for the respondent number 2, has informed that copy of the IA has not been furnished to her. Para. Miss, your name? A. Payang.
A fine.
Miss A. Payang, learned counsel for the applicant, undertakes to serve a copy of the same to Ms. Brown during the course of the day. Para. List after 2 weeks to enable the respondent to file objections, if any. The objection filed by the state is in record. Miss A. Begum, Learned Counsel, APP is present.
Lordship, that may be fixed.
2 weeks, this is given. 2 weeks. Tell us the date of your convenience. Was it given on 20?
Lordship, at,
Oh, we'll have it on 11th?
11.
Yes, 11th? Yes. 11 December.
Publish it.
Item 28.
এই ক্যালেন্ডার কোনো অকমান এইফালে দেখা পোৱা কৰি পাবি এই কিতাপখনে কাৰণ দেখা নাপায় মানে কিতাপখন এইফালে আনো লাগি থাকিব ন কৰিলে আমি দেখা পাম তলখিনি দেখিছো নহয় জানো
আমি দিয়া নাই। কোথায়
28.
Wait, please, Lord.
I'm told the objection is not filed from our side.
You file your objection?
I'll file it within
Okay.
2 weeks or so.
On the prayer of Ms. H. Jahan, learned APP Assam, matter is adjourned by 2 weeks. Matter is adjourned by 3 weeks to enable filing of objections.
Obliged.
Copy.
So, that's good, yes. Oh. Fine. ठीक है, ठीक है.
So I is rejected, it is
Early.
earlier I.
I-
Oh, yes.
This is the second one.
Second.
Second I.
2024 IA.
I have.
Item 21 for hearing.
Main list 21.
Your Lordship,
Yes.
this is an appeal against the judgment of the learned district and session judge, Dishu Lordship. Judgment was passed on 22nd October 2019, Lordship.
Conviction under
302, 304, Lordship.
what is your name? Esdas.
K. Das, Lordship.
Kedas. Madam Jahan, you would be appearing. Case of eyewitness.
Basically, Lordship, it's circumstantial evidence, Lordship.
Circumstances.
Circumstantial
No
evidence.
eyewitness, no direct
Lordship,
evidence.
one eyewitness was there, as per purported eyewitness, but his statements are contradictory to the. Actually, the Lordship, this case is based on dying declaration. The entire matter, dying declaration, and then later circumstantial evidence.
Yes, kindly. Read
What?
the FIR.
Lordship, the affair is on page 3 of the paper book, Lord.
Yes. Who informant is PW?
Informant has already died, Lordship, so he could not be examined.
He's passed away.
Yes,
Okay.
Lord.
Korna Bahadur.
Yes, Lord.
Okay, please,
Lordship.
read the Azhar.
Humble, humble submission is that on 5:30 p.m. today, that is on 28/11/89, Sri Savilal Chetri, son of late Mon Bahadur Kharka Chetri, resident of 9th Mile Manja, came from Manja and grievously wounded co-villager Sri Ganesh Thapa, son of late Savilal Thapa, by stabbing him on his stomach with a kukri, a type of machete, without any reason. I therefore pray to you to take necessary action after investigating into the matter and oblige. Lordship, now the interesting thing here is that the FIR was taken by the police later on, Lord. And this was stated by the IO, who is PW8.
No, this FIR was of 28/11/1989.
1989, Lord. Judgment was delivered after 30 years, Lord. 2019. You said 2019 also. Hmm? 204. Oh, it's 204, Lord.
Yes.
Now, Lordship, if I may point out to the page 47, Lordship, of the paper book, Lordship, paragraph 22.
Receipt permit 27. GD entry it was at 27. Date of incident 20. When was the incident?
It's on 28/11/1989, Lordship, in Manja, near.
No, in the Azahar, what has been pointed out by my learned brother, kindly come to the registration part below the, what about this date? This should be 29 or what?
Yes, Lordship.
Not 27.
Not 27, Lordship. That is also a discrepancy in the intent.
27 or 28 or 29? What?
29. It should have been 29, Lordship. Or maybe 28, but not on 27, Lordship. In page 24, Lordship.
What is the Thana?
Thana Manja.
No, Manja is the outpost.
Thana, Difu, I think. Difu, Thana, Difu.
Page.
When was this registered?
Registration.
28/11, fact, the date of occurrence, 28/11 said, date 29/11, okay. 29, that should be 29/11. That should be 29/11.
Yes, Lord. There may have been some typographical error.
If you come to the registration part, it was registered on 29/11 at
Yes, Lord.
12 p.m.
Yes, Lord. 29/11/89. Yes, Lord. You can register, but if you paste four Lord.
Okay. Then.
Yes, Lord. Now, Lordship, basically the operative part of the judgment is on page 47, Lordship, paragraph 22.
Not go to the judgment, read the positions first.
Yes, Lordship, just I'm coming to that. Lordship, in the judgment with PW1 and 4, they are considered to be a person before which the deceased had made dying declaration, Lordship.
Okay.
Now, if we come to PW1, Lordship, page 8, Lordship. PW1 is Krishna Bahadur Giri. I know the accused.
Who is he?
I think he is one of the, he's not the eyewitness first. If he was one of the witnesses present on the spot, Lord. Neighbor. No, Lordship. That is the thing, Lordship. The witnesses are contradictory to each other.
Please read.
Yes, Lord. I know the accused, I know Ganesh since deceased. On the date of occurrence, while I was resting, Ganesh, deceased, came crying and fell down near my house. I went there and saw Ganesh with injuries crying. He was injured on his stomach. On my inquiring, Ganesh told me Sabilal, the present accused, stabbed him in the stomach. Ganesh was sent to hospital Manja for treatment, and I saw people caught hold of the accused, Sabilal, and was taken to Thana. I was examined by the IO, and later on I came to know that Ganesh died of injury. Now, Lordship, the cross-examination is on page 9. I have not seen that the accused stabbed the deceased at the place of occurrence. I heard hue and cry of many people, and I went out. Before my going out, hue and cry was there. It is not a fact that I was not told by Ganesh about the occurrence. Lordship, now herein, PW1 has stated that the deceased came and fell down near his cliff. But Lordship, if we go to PW4, Lordship, both of whom are considered as the person before whom the dying declaration is
Just a
made.
minute. Madam, আধা পড়া হয়েছে না এটা? কিন্তু বলবো picture wife hanging oh এটা করে দিয়ে ভালো ব্যাপার না দিয়ে একটু আমি আরম্ভ করব এটা করি Mr. Das, there was one matter which was heard in part. We'll complete that matter. That we have just started. We'll complete that matter. Then we'll come to your matter.
Lord.
Madam Borpujari, that matter. That of the wife
Lord.
hanging but feet touching the ground.
Lord.
It's fresh in our mind. Let's complete that. But don't go away. We'll have your matter.
Lordship.
Lordship, on that day, Lordship had asked me to deduce evidence regarding my plea of absconding and the accused not being on the place of occurrence. So in that regard, I have brought the Lordship decision of CC. I just wanted to ask.
On what issue? What is the issue?
Lordship, in this case, Lordship, in my opinion, just it's all
this
based on suspicion.
no,
This
this-
is absconding and the Lordship not being in the circumstantial evidence.
Which para?
Lordship, para 18, Lordship,
18.
Lordship. Circumstantial evidence, Lordship. Generally, when we conviction is solely based on circumstantial evidence. It will be page para 22. Whether absconding by itself establishes guilt of accused, determination of held mere abscondence of accused does not lead to a firm conclusion of his guilty mind. An innocent man may also abscond in order to evade arrest. As in light of prevailing situations, such an action may be
You're
part of
reading which paragraph?
paragraph 22, Lord.
22. Okay.
Circumstantial evidence absconder. My case is related to this. It's only based on circumstantial evidence, Lordship, and the accused, it has been alleged by PW 5 and 6 that he was there on the date of occurrence, but there is no independent evidence as such. So the small child, he couldn't be examined as he is below the age. So only witness is Hawa Bibi, that is the sister of the accused and sister-in-law of the victim. And she herself is having a dispute with property because the deceased on many occasions, she has reminded her to leave the property as she is occupying the place which is not, according to her, the deceased, it doesn't belong to her. And the deceased lordship before her death, she was looking after the construction of the house. She was very much involved in the construction of the house. So a person, a lady who is so much concerned, how can she take these decisions? I mean, how can she be so much abused with her husband? And she has repeatedly told her sister-in-law and niece to leave the premises. And the Bisars were also held lordship regarding this dispute. So this dispute cannot be altogether overlooked, according to my opinion, lordship. And the person's abscondence lordship, it has been stated very elaborately whether absconder by itself establishes guilt of accused. Determination of it. Held mere abscondence of accused does not lead to a firm conclusions of his guilty mind. An innocent man may also abscond in order to evade arrest as in light of prevailing situation. So my humble submission, lordship, the person at the first place, no one has seen the person, that he was there on the date of occurrence. And if he is there, lordship, I agree that he might be there. Oh, he might leave the place of occurrence out of fear, lordship. Everyone has that in their mind, to leave the place as soon as something happens. And if it is if she was tortured, why did the mother of the deceased did not file any complaint? And brother also said that we haven't found anything so vicious within the husband and wife. Mother also is silent, lordship, regarding this whole. Daughter has died, lordship, and the mother, I won't agree, mother would have been very violent and very much hurt, but she didn't say anything in regard to this. And person who said that he went to Aijol, the accused, for me, lordship, there might be possibility. Or if he has come, then maybe when he saw, because in many occasions, the Hawa baby has said that she heard the scream and then she went and then she saw the body and then she went to the person informant who filed if she has seen the occurrence, she should have shouted and she should have called the people around. But instead of then, she went straight.
No, see, has somebody claimed of witnessing the incident? No.
Nobody, lordship.
Then
Nobody.
Where is the scope of shouting?
No, this in one she said this one, lordship, sister of the accused, Hawa Bibi,
PPW5.
lordship.
Where is she?
In one occasion, lordship, maybe she said she heard some noise, but she went directly to the Nurul Islam and she stayed there for the whole night, just out of fear.
No, she has not said that. Kindly come to page 16 of Hawa Bibi, second paragraph. Please read, madam.
I know the informant.
No, second paragraph.
It was a day of the month of Ramadan. We were asleep after having dinner. Then accused came to my house and told me that his wife had died. Initially, I did not go with him, but as the accused insisted that I should go with him, I went to his house, taking my son with me. I saw that inside the bedroom, 2 children of the deceased were sleeping on bed under a mosquito net. Then the accused handed over one child to me and the other child to my son, and then absconded from the place. I had seen the deceased partially hanging with her neck from a beam of a house with the help of her wearing sari. She was wearing petticoat from above her breast. Therefore, I informed the neighboring persons and they came. Thereafter, I informed the family of the informant, who is maternal uncle of the deceased, after the incident. Out of fear on that night, I had stayed in the house of the informant. On the following day, the police had arrived at the place of occurrence and brought the dead body down. The police had also taken photographs of the hanging dead body. I have narrated the incident to the police as I have narrated today. The police had taken the dead body to police,
What kind of injuries were found on the deceased?
only neck, Lordship. And,
Ligature.
yeah, Lordship. And medical report, Lordship, Dr. Ravinder, PW1, Lordship.
And the age of the children were what? Very, very young.
At the time of Lordship, the occurrence, they were very small. Daughter was, I think, smaller than the son. Son was the elder one.
Age around?
Age 5 to 3.
Two. Elder one was two. Elder one was two.
Elder one was 5, if I'm not mistaken.
Three months. তেওঁলোকৰ reaction ৰ কথা নাহিব এতিয়া যদি কিবা হৈছে ঘটনা too small শুই আছে তুমি তাকে ভাবিবা unless social reaction হয় নহয় দুটা পৰিস্থিতি তেওঁ হেণ্ড কৰি মানি পেলাই হেণ্ড কৰাই কৈছে সেইটোতো হয় কিন্তু এটা যদি বেমাৰ পৰা পৰিছে ইমান তললৈকে আহিব নেকি হাৰি হৈছে নাই not only beam হাতখনেৰো support কৰিছে Doctor's evidence is by what?
Doctor's evidence, page number, Lordship. I would like,
Opinion? Opinion?
in his opinion, Lordship, it's a case of complete suicide, Lordship.
Hanging? Non-continuous ligature mark.
Lordship, I would like to draw Lordship attention to page number 8 of the paper book, Lordship. Page number 8 of Lordship. It has been written in his cross. It is a clear death due to hanging.
Possible hanging out that. Any other injury mark on the body of the deceased?
Lordship, no, not as such, Lord.
Let us see the IPM report.
Lordship, medical report is in page number 7 of the paper book, Lordship.
Page number?
7. Ravindra Narayan Das, Lordship.
No, here's the PW1. Let us see the PM report.
Postmortem, Lordship.
Yes. 6-8.
160.
Page 61. The continuous ligature mark. Page 61. Report. There was one What is the implication of one continuous ligature mark, Madam Begum? Continuous ligature mark in the neck, around the neck. One abrasion on the left side of the chin.
Should be non-continuous, but
Come to page 61.
Lordship, yes. It's non-continuous. Lordship, in the medical, there's in the doctor evidence, Lordship, page number 7, there he have stated that there was one non-continuous ligature mark around the knee. And in the postmortem PM report, there is that there was one continuous ligature. Two opinion inputs. PM not tell me with the doctor's report.
See, the examination was done on 6/11/2004, correct?
Lordship,
And the deposition was given on 28th of April,
20th of April 2005.
2005.
5. And it
And he has to depose on the basis of the report.
report.
Okay, first let us, how many witnesses were there?
9, Lordship.
9.
Have we covered all the witnesses? No,
Lordship, that will be covered.
we had covered.
Lordship.
Last one was the court witness.
Lord.
Santosh Kumar Vyas.
No,
Oh, yeah, Lordship.
court witness.
Yeah, Sir Bakhtaruddin Majumdar.
What are your points, madam?
Lordship, my humble submission is, Lordship, that according to my opinion, Lordship, if it had been a case of murder, there should have been some torture on her, which has not at all discovered. Suppose we have taken for granted the husband had done some physical torture on her, and she took the extreme step of committing suicide. Suppose the Lordship, the person would have been there itself, the accused. First of all, she hadn't, it's clearly stated under that first 330 Lordship that he, before leaving the place, he talked to his wife and to his sister also that they should vacate the place as early as possible because it belongs to him. And there has been a dispute forever, for long. And in my case, Lordship, the only witness who have given so much stress on this whole case is the sister and the niece of the
Now, how did the death take place?
that Lordship,
It is a fact that somebody had died.
Lordship,
That nobody is disputing.
Lordship,
We are concerned, how did it take place?
Lordship,
And if the appellant is involved at all,
Lordship.
that is the case we are trying to examine. You have been held to be guilty. Now, what are the points of defense you have formulated? That because of these reasons, the materials which are present will not be sufficient enough to come to a conclusion of guilt. What are the points you have formulated?
Lordship, in my opinion, Lordship, there is no nikah that no documents regarding the marriage. That she was tortured. That it's held, Lordship, that they were married for 4 to 5 years, and there is no nikah and there is no documents as such regarding the marriage.
No, is there anything on record or any foundation that there was no marriage? Are you disputing that she is your wife?
No, not. Lordship.
The sentence conviction is not under, it's 302, I think.
Lordship.
Under, madam?
302, Lordship.
So why are you bringing the aspect of marriage or no
Lordship,
marriage?
only my humble submission is that, Lordship, it's just consider that the law, it might be suicide and not murder. That's my only.
Suicide, then why the feet are touching the ground, the hands are on the wall? Is it
Lordship.
possible?
Lordship, she died on the previous night at 10 o'clock. Suppose she died at 10 o'clock and the body, when the police came, it was the early morning, not early morning, 10. The doctors and the magistrate and the mother of the victim, everybody arrived on that day. Lordship, couldn't it be that body was pushed down? It's my opinion, Lordship.
Is it possible?
There is a
Have you
question,
seen the photographs?
Lordship.
It is not a very marginal place that hardly it was touching. It's not only touching, the entire weight was on the ground. And
Lordship.
even her hands were on the wall was broken. If you have led us to the photographs. Page,
Page 65, Lordship, 65 and 67.
No, no, it is. বানানো হয় ওটা হরিগঞ্জ ইম্পসিবল কিন্তু এইটো বস্তু মানে কাপোৰেৰে তেওঁ হেৰি কৰি ষ্ট্ৰেংগুলেট কৰাৰ ওপৰতে ষ্ট্ৰেংগুল ওপৰৰ পৰা টানি এনেকে কৰাৰ পিছত হেঙিং না ডেটটো ওপৰত তাৰপিছত তলত নমাই দিলে ওপৰত গাঁঠটো আছে সেইখিনি চোৱা নগ'ল আৰু বাচ্ছা কেইটা ইমান সৰুতে ৰিয়েক্ট কৰিব নোৱাৰে সিহঁতে position of the body of the ভুল নহয় correct Madam, the trial court has come to a finding that from the position of the deceased, it cannot be held to be a case of suicide because the feet were not only touching, it was
Standing.
firmly placed on the ground.
Yeah.
You come to page 65. And the next page.
66. Hands
66.
are in the wall.
Hands are on the wall and she is her body, the weight is on the wall. It cannot be a case.
Leaning to the wall.
If it's a case of suicide by hanging, the entire weight has to be carried by the neck,
Rope.
nothing else. Yes, what else, madam? PW5 is not trustworthy as there was previous animosity. That is one of your submission, isn't it? How?
Lordship,
The other one,
Abdul Qayyum, son of Haba Bibi,
PW6
Lordship,
or 7,
6 Lordship,
5 and 6.
Lordship. Other witness, Lordship, Abdul Hussain, they're just neighbors, Lordship, and
In this
Nurul
case-
Islam.
In this case, 106 will not come. Evidence Act.
Proof, Lordship. You'll have to.
See the circumstance. You were staying with your wife. She is found hanging, feet touching the ground. You have no explanation. What is your 313? Page 32.
Lordship.
No, not all. Let us see the what I don't. Oh, that Aizawl thing. You said that on the previous day you had left for Aizawl. That was your defense.
Lordship.
Need to surrender probably. Hmm. Hmm. Two 2019 or টাকা রেস্ট করেছেন এক্সপন করে দিলেন What was your version? Tell us.
Lordship, whether she died of suicide,
No, were you present at the time of the deaths?
Lordship,
Or did you leave for Aizawl on the previous day?
Lordship, I left my for Aizawl
When?
the previous day.
Date?
Date, Lordship,
4th. Is it 4th? Has to be 4th. The information was of 5/11. You have to leave on 4/11.
Lordship,
Then you, what about the children?
Lordship, one, her brother said that the children were found there. The children are given to him. Only Hawa Bibi has said that the children were given by the
No,
accused.
living for a moment, let us forget what the prosecution has said.
Okay,
The PW 5 has said that you hurriedly had given the children to them and you left.
Lordship.
You absconded. You said that you had left for Aizawl on the previous day.
Lordship.
That means you had left your wife and children
Lordship.
in your home and the incident had happened. After the incident, you did not even bother to come to ask what has happened or what. Don't you think that it is unnatural? You are in Aizawl, something happens in your, you get the information that something happened, very serious thing has happened in your home. First thing will come back. It's not a case of absconding also. You say that you abscond when something has happened. You say that you are trying to take a case of LIB, but though you have not proved, no DW. Last question, have you seen question number 16? Do you want to adduce any evidence? No. You could have very well set up a case that I was not even there, I was at Aizawl.
Lordship.
That's not the platform. So the LIB thing has gone. Now, even for a moment, if you think that you are in Aizawl, you had left for the previous evening or previous day, on getting to know about the information, you did not come back.
Lordship.
Don't you think that's a heavy burden upon you under 106? Let us see 106. Okay, evidence. Section 2 লিখে দিব এটা থটটা ইজি মোবাইল জজমেন্ট এজেন্ট অলরেডি ডিকটেশন দিয়েছিল কিবা কাউন্সিল দিয়ে আছিল কোর্ট হলো মাথা মারা কেন পঠাই দিলাম পঠাই দিচ্ছেন কি ধুনীয়াকে মানে আমার সেই সেইটো অভাৰকাম কৰোঁতে মোক কৈ দিলে সময় লাগিব কিন্তু মইতো নাহে একোৱেই নাজানো 300 to 302 to 299 কি সেইকেইটাও নাজানো সোমাই এটলিষ্ট সদায় লাগি থাকে ভাবিছিলোঁ কম্পেৰিজন ষ্টেটমেণ্ট ধুনীয়াকৈ দিয়া আছে মেটাৰ আহি আছে বেলত ইয়াত কিন্তু ৰেকৰ্ডিংটো ভুল হৈছে নেকি maybe out of fear I did not come back from Aizawl. Next line to নিমিলে দেখোন নহ'লে নহয় তেওঁলোকে সেইটো কিয় বনাব চাপ'জ সেই গণ্ডগোলটা কৰি সি আইজলত পলাই গ'ল তেওঁলোকে এইটো কিয় ভাৰ্চন দিব যে আমাৰ ভাই বাচ্চা কথা দি গ'ল তেওঁলোকে এনেই ক'ব লাগে এনিমেচন হিচাপত আছে আমি গম পালোঁ কিবা এনেকুৱা দেখিলোঁ বাহিৰৰ পৰা দেখা পাইছোঁ গম পাওঁ হেৰি কৰি আছে ন গৈ পেলাই বাচ্চা দুটা সেইবিলাক কান্দি আছে University court again goes to. You had any question? 15 of question number 15. Whole question number 50. Freelance is not a business. What does not mean? Committed rape on my wife 2 days pregnant. That's it. It is not our incident. The police case ke liye. Rape and 2004 to 2019 like exam pay successfully. 2005 or 15, 14 years. They killed my wife. In case of strangulation, manual strangulation, negative the kind of strangulation by pulling both hands by himself is one possible one possibility. Other possibility to tie a knot and hang. And it what beam to do and it animals. আৰু মানুহটো ৱেটটো পিছত এনেকে শাৰীৰ নিচে তলত আহি আমাৰ যি নামিব সেইটো স্প্লিট ছেকেণ্ডতে নামি যাব মেক্সিমাম ষ্ট্ৰাগল তেতিয়া হয় যে মেক্সিমাম তলত তেতিয়াই নহয় Okay. What else, madam? What else? Anything else?
Lordship.
Yes, Madam Begum.
Lordship, as we have stated, Lordship, that in the 313 Lordship, question number 15 Lordship, 15 Lordship. May I read Lordship?
Just a minute, please. Page 36.
Lordship,
Question 15.
Lordship.
Yes.
Hawa Bibi, TW5 is my sister, who are being left by her previous two husbands took shelter to my home about 8 years. 8 years she was there, Lordship, but she have never stated that she have any enmity with her sister or some transaction of money was there, Lord. Fact of the alleged incident, and accordingly I allowed her to stay at my home. My sister Hawa Bibi has two sons from her previous marriage, namely Abdul Qayyum, PW6, and Imran. Both the sons of Hawa Bibi committed rape on my wife 2 days prior to the incident, which was informed to me by my wife 2 days prior, Lordship, and he is totally silent about that incident, Lord. He have never complained or never gave an FIR, Lord, to such a heinous offense, Lord. Two sons. As such, I asked Hawa Bibi and her son to leave my home and asked to give back my money. At that only at 3:13 he have stated that he have given the money or something. And defense have never taken the plea, Lordship, that such an incident was there. It's totally baseless and false, Lordship. There is nothing such that she was raped or she have some. And 8 years, Lordship, one enemy is staying there and he have no complaint. After such instruction, I left for Aizawl. Subsequently, having such a incident in his home, Lordship, he left for Aizawl in the next day. Then in the next day, and subsequently I came to know that they killed my wife. And out of fear of my life, I did not return to my home. That is one thing, Lord. And Lordship, when PW Lordship seven, Lordship,
Informant.
Lordship, in his Lordship evidence, Lordship, he have never stated that he have some enmity with his sister, Lordship.
7 is the maternal uncle.
Maternal uncle, then maternal uncle have never stated that this is sister-in-law have some enmity with them, Lordship.
Hawa is not his sister-in-law. Hawa is his sister.
Hawa is the sister-in-law of the deceased, Lord.
Yes.
And Nurul Islam is the uncle of the deceased, and he have never stated in his statement that Hawa Bibi have some enmity with the deceased. Nobody, Lordship. In the evidence, nobody have stated. All our neighbors, Lordship, that they have some enmity with the deceased. And there is no single whisper in the defense, Lordship. Regarding such a wild allegation, Lordship, such a heinous crime was done, but there is nothing such, Lordship. And taking a plea of alibi, Lordship, he could have adduced some evidence, Lordship, in his defense, but nothing is there, Lordship. How could it be believable, Lord? Even his small children was given to his sister. He have no complaint. He have never ranked that don't give my sister to a daughter to that person who have killed my wife.
That is the version of Hawa.
But Lordship, after PW8, Lordship PW8, page number 25, the brother of the deceased, Shabuddin.
Yes.
Last paragraph, Lordship. We had taken care of the two children of my sister and had brought them to them that all the residents had brought them to their residence Later, the accused sister had taken the infant daughter of my sister. Deceased brother had said, if she have killed the deceased lordship, how could they give the daughter? Clearly, lordship, the postmortem report tally lordship that there is a ligation mark beyond the no, it's non-continuous mark. It is continuous mark, lordship.
Non-continuous,
No, in postmortem, it is continuous,
non-continuous.
lordship.
It's a typographical error, not typographical.
One
While transcribing, non has been missed out. Original has got non. You see his evidence. In the evidence, correct thing has been recorded. If it is non-continuous,
fact is that lordship, after hearing such an allegation from his wife, lordship, that she has been raped, he have left his wife on the next day, lord. How could it be believable that lordship, after having such an incident, the two person have raped his wife, and he having two children, how can he leave his wife and he went for idol, lord? Totally unbelievable, lord. And the position of the dead body, lord, clear that she is murdered and she was hanged. And there was, and even the PW lordship, though it is unbelievable, lordship, PW 6, he have heard the
just a minute,
conversation.
just a minute. The material থাকিব লাগবে reflect that. Like that he need evidence দিব লাগবে. Only from other evidence that annuity should reflect. He plea to GP plea লয় ল'ব পাৰে. হেৰি কি PW 6 5 কি ক্ৰছ কৰিছে চাওঁ. হেৰিছো. এটাই আছে paragraph 8 page 18 page 18 it is not a fact. It is very normal proof, not specific at all. এই লাইনত প্রশ্ন হয় ওয়াইফৰ কিবা এনেকুৱা ধৰণৰ কৰিছে. Madam, yeah, how do you reconcile the medical evidence? And question to both of you. Medical evidence says non-continuous, which gives the impression of hanging.
Hanging. But in the inquest also, lordship, there is in the
At the
inquest
same time, the feet are touching firmly on the ground.
ground.
How do you explain the position?
In inquest there is the
Photographs have been have been proved. Those two photographs exhibited.
exhibit. Yes, Lordship. Exhibit 1-1.
No, exhibit
No,
one is the PM report.
No, PM report. Photographs.
Photographs exhibited, yes,
Exhibited, exhibit 3, Lordship.
exhibited.
3. 66,
Yes,
Lordship.
exhibited.
Exhibit 3 is
How do you reconcile? Medical evidence says, indicates it is a case of hanging.
hanging.
Hanging maybe a suicidal, it may be homicidal.
Homicide.
But if you strangulate by the sari, manual strangulation,
There is some injury marks were also there, but it's not in the PM report.
no, it's there in the PM report. There is one.
There
there
is
is
blood
one-
stain from her anatomy in the inquest.
No, that is the result of hanging. The injury there is, come to page
The
61. One abrasion mark is there.
Lordship.
Condition of subject stout.
Lord.
So and so, last one abrasion over the left side of the chin,
Lord.
about half inch,
There
half
one.
inch length.
Difference between strangulation and hanging.
Medical jurisprudence. And continuous. It non-continuous is like continuous is strangle. Ground. And hands are leaning wall. Non-continuous. Hanging. Not hanging. It's not, and the injury is also there. Neck. Firmly on the ground. The injury is also there, Lordship. Injury mark is there.
Very minor.
circumstance with in lordship, the chain of circumstance is complete because no evidence, Lord, no prosecutor have said that he had some enmity with the 302. True. PM report is there is the chain is there at the Lord. Lord. But it is 302. Lordship, there is a Lordship, as per the postmortem report, injury was found on the dead body beyond the ligature mark on the neck, which duly supports the fact of the deceased being assaulted prior to her death. The manner the dead body was found hanging as being deposed by all the prosecution witnesses incorroborates, does not suggest such hanging to be a suicidal, rather proves the same to be a homicidal. That is what it of the skin only. In between the in between. There was one continuous ligature mark round the neck in between the sin. Non-continuous. I'll correct it. Around the neck, in between the sin and
Because no, had it been suicide, the thyroid, the ligature mark will be high up the neck,
up the neck.
above thyroid cut. So this is between.
On evidence of
Original
one
to the
original.
thyroid neck.
It is not evidence of the doctor. Ligature mark around the neck in between the sin and the cartilage. CRICU. Mm. Mm. Thyroid walls, ribs, cartilage are intact. Lower, lower than thyroid record. And wall of the ribs and thyroid is only wall of thyroid ribs or cartilage are intact. Wall, ribs, cartilage, intact. Thyroid. Congested thyroid wall, rib, and cartilage intact. Okay. That is Lordship, the position page number 7, Lordship. From PM Lordship. Okay, sir. It is that is Lordship. Record is below thyroid. thyroid is intake in the evidence. Right? Yeah, that's all. Wall strip cut. Thyroid food to thyroid. Intake. Intake. Wall, breathe, and cartilage intake. Thyroid. ইয়াতো মই পাই মই আছে এটা পুৰণা থাকে আৰু নাই ঠাই মই হেৰি কৈছে নাই
Low down in neck. Low decoid or before the base.
No, Lordship. It was not only 4 5 years assumed because she have only 2 years old one son. And but there is no such document. It, after date is not there, but her brother has also said that before 4 5 years, PW. Lordship. 64. Lordship. Lordship. Ground. Leaning to the wall. Half wall. Lord. Lord. Lordship. Before that. Lord. On the ground. Half wall. Not possible. It's not a longer. It will be this position. It will not settle to the left.
Whole life she was there.
So still Lordship. Elongate also.
Sari Lordship, if it is a silk sari, it will naturally go down. Lord. If it's silk, if it's a cotton tight very firmly, then it's
Not. No, elongate. See, it's directly not in, not touching that. It could, it, after that, Lordship, then in our ethical.
Sorry. Sorry. I can read it. But it's totally based on the murder lordship because he couldn't prove himself lordship. In 106 also he have not proved himself that uh he have not done this act and how he have left his wife after such a heinous crime. He have surrendered lordship in one of the with lordship. Lordship, my simple submission is Lordship, the same Lordship. There is no evidence against me, Lordship. Lordship. I have been convicted solely on the
Lordship, this decision may be upheld, Lordship, because it's a clear case of murder, Lordship 302. The chain is also completed, Lordship.
Put it here, start that there is this neck stretched and fresh body. Neck and fresh. Fresh.
I'm a obliged, Lordship.
May I please, your lordship? Lordship, earlier I had stated the deposition of PW1 lord. You want to? The FIR, should I start with the FIR? Lord. No, lordship. Yes, lord. PW1. No, but PW1, my name is Krishna Bahadur Giri. I know the accused. I know Ganesh since disease. On the date of occurrence, while I was lordship, it's on page 26. Not 26, lordship. Page 47, paragraph 22, lordship. The court assumed the declaration made by disease before PW1, mean PW4 can be considered to be dying declaration. The word dying declaration means a statement, written or verbal, of relevant facts made by a person who is dead. It is the statement of a. Yes, lordship. Yes, lord. Yes, lord. On my inquiring, Ganesh told me Sabilal, the present accused, stabbed him in the stomach. Ganesh was sent to hospital Manja for treatment, and I saw people caught hold of accused Sri Sabilal and was taken to Thana. Now, lordship, now the cross-examination is there. I have not seen that the accused stabbed the disease. At the place of occurrence, I heard hue and cry of many people, and I went out. Before my going out, hue and cry was there. It is not a fact that I was not told by Ganesh about the occurrence. Lordship. This is the statement of PW1, lordship. Now, please go to the PW4, lordship. It's on page 14, lordship. Yes. It's Meena Devi. She is the wife of late Karna Bahadur Setri, who lost the FIR, from whom FIR was taken. Lordship. Now, the deposition is, I know the person at talk now. I also know the complainant, my husband, since deceased Karna Bahadur Setri. About 4 years ago, at about 6 p.m., I was at home with my children. Sri Ganesh Lama came to my residence with physical injury on his person and lied on my premises. He seldom talked at that moment. On being asked, he told us Sabilal caught him. I shouted. People of the locality assembled. Public arrested Sabilal and took him to Thana. Injured Ganesh Lama was also removed to hospital by police. Bal Bahadur and my husband was present at that time. After 5 days, Ganesh Thapat died in hospital. In her cross-examination, she has stated that, lordship, I had not seen the occurrence at spot. Nora Bahadur and Dal Bahadur was present and none else at that time. It was in the evening. Persons above named heard the statement of Ganesh. My husband died 1 year ago. My husband asked Ganesh Bahadur about the incident. It is not a fact that my husband did not ask Ganesh Bahadur about the incident. People arrested Sabilal on street. I was not going to the street. I was not told by anybody. I heard about arrest of Sabilal through Hal. Now, lordship, as per the statement of PW4, the deceased has come to her residence. And as per Krishna Bahadur, PW1, the deceased has come to his place. There is inconsistency between both PW1 and PW4. Then, lordship, PW4 had stated, on one she had stated that Paul Bahadur and my husband was present at that time. Near my house, lordship. But here, PW4 stated that deceased had come to her residence, lordship, and lied there. I'll be coming to that, lordship. Yes. 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 Lordship. PW2 is one of the main witnesses, lordship. Actually, PW1 of the PW2 is the one who took the deceased to the hospital. He is Rishi Bahadur Chetri. PW2, I may read, lordship. Page number 10, lordship. I know Sri Sabilal Chetri, who is now at dock. He resides near my house. I know Ganesh Thapa deceased. About 4 years ago at afternoon, while I was milking the cow, I heard din and bustle about killing of man, and I came out from home and proceeded to the place of occurrence on main road. I saw Ganesh Thapa lying with injury on his belly. Many people gathered there. I took Ganesh Thapa to Thana with one Gante OC. Deputed Ganesh Thapa to Manja Hospital. Doctor gave first aid and forwarded him to Difu Hospital. On way to Difu Hospital, Ganesh was senseless. He did not refer to anybody's name. After 4 days, he died in the hospital. After conducting PM, doctor allowed to take back the body of Ganesh Thapa home. Exhibit 1 is the inquest report and Exhibit 1 is my signature. After 3 days at the hospital, I heard police arrested Sabil. Now, Lordship, the cross-examination, the place of occurrence is at distance of more than a furlong from my residence. I went alone to the place of occurrence. Many people assembled there. On my arrival, I saw about 20 persons there. Ganesh Thapa was properly dressed. Gante went to PO after my arrival. Lordship, in fact, PW1 took the deceased to the hospital. And at that time, he was basically senseless as per the PW2. PW2, Lordship, PW2. He took the deceased to the hospital. Deceased didn't refer to anybody's name before PW2. And since Lordship deceased was for the longest time with the PW2, his evidence becomes much more material in PW1 or PW4. And Lordship, PW4 is also stated in his evidence that Ganesh Thapa was lying on the road, not in anybody's residence. And also, Lordship, PW2 did not mention anything about PW1 or PW4 or about the informant as such. Then Lordship, PW3. PW3 is the father of, I think, no, he's not the father. Mohan Bahadur Chetri. Now he deposed as follows. I know Sri Sabil. Yes, Lord. Yes, Lordship. Yes, Lordship. Yes. Something has already happened, Lord. On his belly. Yes. One contact. Yes. Yes, Lordship. Yes, Lord. Yes, Lord. Then Lordship, PW3. Lord. I know Sri Sabilal Shetty, who is my neighbor. I saw Ganesh Thapa. About 4 years ago, in the evening at about 6 p.m., on my way back from Bazaar, saw Ganesh Bahadur lying on the road with injury. Ganesh Bahadur took to hospital and Sabilal was taken to Thana by police. From the PO, my son Rishi Bahadur wanted to Ganesh to hospital. Kukuri was recovered from. This is PW3, Lordship. This is PW2. Rishi Bahadur Chetri. Yes, Lord. To Ganesh to hospital. Kukuri was recovered from a distance from the place of occurrence. Police seized it. Exhibit 2 is the seizure list and Exhibit 1 is my signature. Material Exhibit 1 is these two. Now, for his cross-section, not such, Lordship. Kukri was recovered at a distance of 1 furlong from the place of occurrence. I put my signature on the seizure list of the son. PW3 has also affirmed, Lordship, that the deceased was lying on the road, not in anybody's residence, Lordship. In Lordship, one of the foremost conditions of dying declaration is the fitness of mind. If PW is saying that, PW2 is saying that deceased was senseless most of the time, then what is the guarantee that he had made such? Lordship. Yes. But that, I mean, that casts exasperations on the mental state before the occurrence. Lordship. I mean, before this, he was taken to police station, to medical. Lordship. That's what I was. Yes, that is it. No, PW4 we have already gone for. Yes, Lord. PW4 Sri Meena Devi Setri was yes, allegedly died in clash and had been wife of late Purna Bhadra Setri. I know the person at dock now. I also know the complainant, my husband, since deceased Purna Bhadra Setri. About 4 years ago, at about 6 p.m., I was at home with my children. Sri Ganesh Lama came to my residence with physical injury on his person and lied in my premises. He seldom talked at that moment. On being asked, he told that Sabilal cut him. I shouted. People of the locality assembled. Public arrested Sabilal and took him to Thana. Injured Ganesh Lama was also removed to hospital by police. Police Bal Bahadur and my husband was present at that time. After 5 days, Ganesh Lama died in the hospital. Now, in her cross-examination, she has stated, I had not seen. Now, Lordship, here in PW4 has stated, clearly stated that the deceased had come to her house, her premises. Lordship, while PW1, 2, and 3 stated that he was on the road, Lordship. That's a very big disturbance, Lordship, in my eyes. And Lordship, no, Lordship, in her deposition, she had stated that her husband and Bal Bahadur were present at that time. Last line, Lordship. Bal Bahadur and my husband was present at that time. Not examined, Lordship. Bal Bahadur has not been examined. Her husband already passed away. And in her cross-examination, she has stated, Nor Bahadur, Dal Bahadur was present and none else at that time. And Lordship, she also stated in her cross examination Now, Lordship, we are going through the deposition of PW4, Lordship. Now, Lordship, he has stated in a deposition that, first of all, that Ganesh Lama came to my residence with physical injury on his person and lied on my premises. He seldom talked at that moment. On being asked, he told that Sabilal cut him. Now, Lordship, further she has stated, Bal Bahadur and my husband was present at that time. However, in her cross-examination, she has stated that I had not seen the occurrence at the spot. Nor Bahadur and Dol Bahadur was present and none else at that time. Then, Lordship, he further stated it was in the evening. Persons named above heard the statement of Ganesh. So, Lordship, Nor Bahadur and Dol Bahadur were the main persons who should have been examined, but they were not. Then, Lordship, she stated, my husband asked Ganesh Bahadur about the incident. So, Lordship, it is not clear whether the deceased made any statement before her or before her husband or this Nal Bahadur and Dor Bahadur. Korna Bahadur, Lord. Yes, Lord. He passed away. He was the person from whom the IO had taken the FIR, Lord. Lordship. Then, Lordship, I'm going to PW5, Lordship. PW Chitta Bahadur Chetri. I know the accused Sobilal, who is my elder brother. We live together. I know the deceased Ganesh Bahadur Thapa. About 6 years back, when I was at home in one evening, I was at home. My brother was not present at home. I don't know whether there was any other person. When I came out of my house, I heard hue and cry coming from the roadside. I went towards the road. I came to know from the public present there that a quarrel make out there. Afterwards, I came to know that one Sabilal was arrested by police in this connection. Then I went to Thana, where I came to know that there was a quarrel between Ganesh Bahadur and Sabilal. I saw the deceased Ganesh Bahadur Thapa from a distant place. Thapa was taken to hospital. Later on, I came to know that Ganesh Bahadur Thapa had died. Police also inquired these things from me and I gave the same reply. And in his cross Lordship, yes. Now, Lordship, the pertinent point herein is that brother of the accused has not mentioned of any previous enmity between the accused or the deceased, nor did any PW mention any such enmity or such motive on the part of the accused to stab the deceased. Then, Lordship, PW6 is the witness of the deposition of the doctor who conducted the postmortem, Lordship. On 2nd December 1989, I was at Tifu Hospital as MO and HO. On that day, I prepared the PM of Ganesh Thapa, male 18 years, Nepali. As per police acquisition in connection with Deepu PS case number Iman, dead body was identified by Constable 170 Jiten Chandra Bora and Rishi Bahadur Setri and Kamal Setri, both are related of the deceased. On external appearance, a male, now Lordship herein, an important thing is that Rishi Bahadur Setri, he is PW2. Herein it is stated that he is a relative of the deceased, Lordship. Related of the deceased. And Lordship, Rishi Bahadur Setri had not mentioned that the deceased has stated to him that Sabilal had actually stabbed him or injured him or anything. In fact, both of them were related. Still, Lordship. And it was Rishi Bahadur. Yes, Lord. 1 and allegedly before 1 and 4, Lordship. one, Krishna, Krishna Bandhu. And 4 is the wife of Karna Bahadur. That's the thing. If it in all probability, I am a person is in a better position to talk to his relative than some unknown person. But it was Rishi Bahadur who took him to the hospital. No, first he took him to the police station. After that, he took him to the hospital. Yes, Lord. Yes, Lord. Lord. Yeah. Lordship. On external appearance, a male post-operative dead body with rigor mortis present. The stitches present on the exterior abdominal wall and left side of the thoracic wall. The eyes are closed and abrasion present on the right side of the waist. To cranium and spinal cord, all are normal and no deformity detected. Thorax, 7 and 8 ribs of the left side of the thorax are broken due to sharp cut. Repaired left thoracic wall present. Diaphragm is cut on the left side and repaired. Pleura of the left side of the thorax was lacerated. Larynx and trachea and right lung normal. Left lung cut wound present on the lower part of the left lobe. Pericardium, heart, and normal. Abdomen on interior abdominal wall, stitch post-operative was present, and 2 stab wound present with drainage tube. Here the interesting is 2 stab wound, not 1. Here 2 stab wound with drainage tube. Peritoneum, saturated material present with old clotted blood present. Mouth, pharynx, esophagus normal. Stomach empty. Small intestine full of intestinal fluid. Large intestine full fecal matter. Muscles, bones, and joints. Injuries are already described above. Abdomen, liver, left lobe of liver is repaired due to cut injury. Spleen, kidneys, bladder, organ of generation normal. More detailed description of injury or disease. Abdominothoracic injury and cut injury of pleura. Left lung and left lobe of liver injury also present on diaphragm. All these injuries are antemortem, which was operated. Such type of injuries are due to penetration by long, sharp cutting weapon. In my opinion, actual cause of death is due to hemorrhage and shock as a result of vital injuries to vital organs like liver and lung. Now, Lordship, my humble submission is the death is due to hemorrhage and shock. If it's present after 5 days, Lordship, so at the time of the incident, it raises if the deceased was in a state of shock and delirium, then what he has stated, Lordship, before the 1 and 4, PWs 1 and 4, it's highly doubtful, Lordship. Then in his cross-examination, he has stated, I caused the PM at hospital morgue. I alone did it with help of sweepers. I prepared the PM report in my office and not in the morgue. I prepared this report copying from the notes prepared at the time of examination. I examined the dead body and prepared report on the same day. Civil surgeon's counter signature was taken on 14/12/89. The original notes were put up to CS at the time of obtaining counter signature. About verification, the word is recorded. The papers where I jotted down the points cannot be produced. Lordship, as per the cross-examination, he had prepared the PM report on the basis of the notes prepared, but he has not stated where the notes are, or he has not presented it before the honorable trial court. So that raises a certain questions regarding the PM for my submission. Lordship. Lordship. That is a yes, Lord. Okay. Now, Lordship, we are coming to deposition of PW7. Lordship, in this regard, PW7, Lordship, the supposed eyewitness, Lordship. Lordship. Now, here in Lordship, The PW7, he has deposed before the court, learned trial court in 1998, Lordship, period of after 9 years. The incident had occurred in 1989. So it is after a period of 9 years that the deposition has been done, Lordship. And being a primary witness, he should have been the first one to have been summoned by the Lordship. Lordship, hearing it is not been recorded. However, in the original deposition sheet, it has been read over and explained 12/1/1998. It's 1989, Lordship. 22nd October 28/11/1918. I know the accused Sabilal of Manja. I do not know his residential address. I know that this is Ganesh Thapa about 7 years back. In one evening, while I was going to Manja Bazar along with Koila, Ganesh Thapa, to have some refreshments, Sabilal, the accused, and one another followed us. When we reached near Karna Bahadur's residence, Ganesh Thapa went nearby to pass urine. We were standing nearby. Ganesh Thapa was attacked by Sabilal after some altercation and was stabbed with a kukri on his illegible. Now, this part is illegible. He was taken to Karna Bahadur's residence. Then we tried to catch the accused, but he fled. Then Ganesh Thapa went to Krishna Bahadur's residence, from where he was taken to Manja PHC, and police also informed. Police arrived. Then Sabilal was arrested, but Adar was not found. The khupri was also seized by police. Police investigated the matter and my statement was recorded. I do not know whether there was any bad blood between them. Now, Lordship, can I just come to the cross-examination? Koila Ganesh Thapa was with me. We, patron, proceeding to Manja Bazaar from Manja Sugar Mills. The incident took place about 1 km away from Manja Tiniali. Sabilal resided near Sugar Mills. Sabilal was accompanied by another boy whom I could not recognize. The place where Ganesh Bahadur passed urine was about 15 meters. It was dark night. I did see who stabbed Ganesh Bahadur. Now, Lordship, this statement I did see, it should have been did not see. And Lordship, this has been recorded in the judgment in page 46, Lordship, para 21. Original Lordship, in the original there was a word which was, I mean struck off or something like no initials were there of the learned judge. Lordship, if I may refer to para 21 of the judgment, Lordship. Lordship, I may read para 21 of page 46, Lordship. The paper. No, basing on the cross-examination, the learned defense counsel has contended that there is doubt that PW7 could identify the accused in the field. Though PW1 has stated in his cross-examination that he did not see who stabbed the deceased and that fateful night was a dark night. But his evidence clearly shows that before stabbing the accused made altercation with the deceased. His evidence also shows that the Lordship, now the important point here is that the court has stated that though the PW7 has stated in his cross-examination that he did not see who stabbed the deceased on that fateful night. So Lordship, it should have been did not see. Okay. Okay.
Others I could.
He also has stated, Lordship, that it was a dark night and the place of occurrence was around 15 meters away from where he was standing. So, Lordship, his statement that he did not see that seems to be true. Because on a dark night, 15 meters distance is quite a distance for. And Lordship, in his deposition, he has also stated that one another. Now, who was that one another? He could not remember. And along with him, there was another person, namely Koila. Koila has not been examined. This is the thing, Lordship. So, Lordship, his testimony, I mean, his deposition is doubtful. Lordship, if I may refer to page 45, Lordship, there are 70, the judgment, Lordship. It's stated here in the judgment. It is evident that two independent persons saw the occurrence. They are Sri Sushil Nath and Koila. The prosecution has examined Sushil Nath, who has stated in his evidence that at the time of occurrence, while he, Koila, and deceased were coming towards Manja Bazar to have some refreshment, the accused Sabilal and one another followed them. When they reached near the house of Karna Bahadur, Ganesh Thapa went nearby to attend natural call. They were standing nearby. Accused Sabilal attacked Ganesh Thapa after some altercation. The accused stabbed him with a khupri on his body. The case diary is silent as to who was the said Koila. The man who was accompanying the accused was one Lakshmi Rai. Lordship. The investigation officer examined the said Lakshmi Rai under section 161 of the CRPC, but the prosecution could not examine him during the trial as he had already died. Now, Lordship, the question arises why Lakshmi Rai was not taken into custody. Since both of them were together, Sabilal and Lakshmi, he should have also been taken into custody, but he was not taken into custody. Lordship, it has not been given the judgment, Lordship, when he passed away. It's 30 years, Lordship. So in the meantime, PW8, Lordship. Lordship, in his cross-examination, PW7 also stated Mon Bahadur with his son and about 10-12 people assembled there. Others I could not remember. So Lordship, he stated about Mon Bahadur and 10-12 people. He did not say about Karna Bahadur or his wife or any other or PW1 as such. Then Lordship, in his deposition, PW7 stated yes, he stated. But PW4 stated that the deceased has come to their place on his own. He did not say that he was accompanied by anybody else. And then he said he has deposed there. After that, the deceased went to Krishna Bandhugiri's house. Now, Lordship, how come a person who has been injured in such a major way go from one house to another? Yes, ma'am. It's my. Okay. Okay. Itu na. এই নহয় নেকি দতে দিয়া যেন পাইছো কৃষ্ণ বন্ধু's house is just not not shown. C বুলি তো লিখা নাই B to তো দিছে indicating place from which the kukri was used. C to দেখা নাই It's silent as to where C and Krishna Bandhugiri's house is. Lordship now in his deposition, P27 also stated that I do not know whether there was any bad blood between them. So there is no probable reason of any altercation occurring between them. And he has himself stated it was a dark night at a distance of 15 meters. So Lordship, the entire deposition is doubtful. And Lordship, on page 51, Lordship, there is another questioning, Lordship. Page 51, para 27, Lordship. It is found from the statement of Ram Bahadur Sethi. Time actually, Lordship, some are saying 5:30, some are saying 6. There is no this. Yes, Lordship, but as a yes, Lordship, but the thing is that Karna Bahadur was not actually the primary informant. The primary informant was one Til Bahadur. And Til Bahadur was not examined by the IO or the prosecution, Lordship. It was on the basis of information of Til Bahadur that the GDNP was recorded, Lordship. The FIR was later taken from Karna Bahadur. And it's in the deposition of PW8. Even Lordship, PW1 has not stated as to what time the incident had occurred, either in his deposition or cross. PW1 is Lordship Krishna Bandhu. Bandhu. Yes, Lord. Yes, bank declaration, but the time of incident has not been mentioned by him, as stated mentioned. Because Lordship PW4 has stated that there was 6 p.m. Lord. page 45. Now, Lordship, just before going to the next witness, kindly have a look at page 45, Lordship, para 18. 45, Lordship. Yes, sir. There. Para 18, Lord. According to the statement of one Ram Bahadur Setri, recorded under section 161 of the CRPC, he was with the deceased and PW7 at the time of occurrence while they were coming towards Manja to have some refreshment and saw the accused having altercation, stabbing the deceased with kukri on his stomach. But he has stated in his evidence that he did not see the occurrence. However, he heard the accused had killed the deceased. And Lordship, this Ram Bahadur Setri is actually PW10. But Lordship, PW7 has not mentioned the same fact that Ram Bahadur Setri was with him. Page number 45, para 18. And this has also been stated in page 51, Lordship, para 27. It is found from the statement of Ram Bahadur Setri. Lordship. Lordship. PW8 is the IO, Lordship. Vivekananda Das. On 28/11/89, I was at Manja OP as IC. On that day, one Til Bahadur Setri informed verbally about 6 p.m. at Manja OP that one Sobilal Setri of Manja 9 village wounded Ganesh Thapa of same village by a kukri. Then I made entry in GD void number Iman. Then I rushed to the PO with my staff. We found on the way to the PO that accused Sobilal was caught by village people and he was arrested and brought to the PO. I investigated. In the meantime, the victim was sent to the hospital for treatment accompanied by Hembora ASR. While the accused was asked, the accused stated that he attacked and injured Ganesh Thapa with a khugri. The wooden handle of the khukri was in the hand of the accused. As stated by the accused, we could recover the handleless khukri in a nearby jungle near the PO. Then the khukri was seized. Exhibit 2 is the seizure list and 2.2 is my signature. Material Exhibit 1 is the seized khukri. Then the formal ejahar was taken from one Karna Bahadur Setri as the incident took place in front of his residence. The available witnesses were examined. From the statement, it was proved that Ganesh Thapa was murdered by Sobilal. Then I came back to the OP along with the accused and seized khukri. Then I wrote to DFU PS for registering a case under section 326 IPC. Exhibit 3 is the Azahar and 3.1 is my signature on endorsement. Sobilal was kept in the OP for the night and referred to the court the next day. Next day also I recorded the statement. Next day I came to the hospital for his statement. Ganesh Thapa stated that he was attacked and wounded by Sobilal while on way to Manja. On P1289, OCPS Difu informed that the victim Ganesh died at Difu Civil Hospital. On getting information, I prayed the court to add section 302 IPC. Inquest was done by Prasanta Fukan over body of the victim Ganesh Thapa and PM was also done. I collected the paper, that is inquest report and PM report from Difu PS. Finding prima facie evidence against the accused on Dr. Sobilal Setri, I submitted the charge sheet under 302 IPC. The accused Sobilal Setri is on document. Now, in his cross-examination, he has stated, Lordship, I did not record the statement of the first informant. No prayer was made for dying declaration. I did not seize the handle of the khukri said to have been found in the hands of the accused. No signature of the seizure witnesses was taken on the wrapper of the M exhibit. It is not a fact that the seized khukri is not produced before the court. I obtained the FIR later on, considering it to be necessary. The PO is about 3 kilometers away from the OP. It is not a fact that Sobilal did not confess the murder of Ganesh Thapa. Now, Lordship, as per the IO, Lordship, the primary informant was Til Bahadur Setri. So, his statement is very much important in this case. The FIR that was taken from Karna Bahadur Setri was later taken by the police, considering it to be necessary. It was not a voluntary, Lordship, voluntary act of Karna Bahadur Setri. Then, Lordship, The deceased was in the hospital for 4 days. So any declaration, any dying declaration could have been recorded in the presence of a magistrate or a doctor, but no such effort was made. Also, Lordship, the police did not exhibit the handle of the kukri. He has stated himself he has not exhibited the handle of the kukri, as he has said that he has tasted it from the accused. Lordship, the kukri, the handleless kukri, it was not sent for any FSL or any other examination for any fingerprints or anything. In fact, Lordship, there was nothing linking the murder weapon to the accused. Lordship, in his deposition stated the wooden handle of the kukri was in the hand of the accused. So, Lordship, it is pertinent here why the wooden handle was not seized or produced by the IO, Lordship, or the prosecution, Lordship. That is a pertinent question. Then, Lordship, the statement of Hembora ASI was not recorded. As per the IO, the deceased stated before Hembora that the accused, the accused had confessed before the ASI that he had stabbed the deceased, but Hembora was not examined. Then, Lordship, in the deposition, the IO stated that was the formal FIR was taken from Cornabara City as the incident took place in front of his residence. In front of his residence, not in his residence, Lord. And there is no mention of PW1 residence or PW1 as well, or PW7, Sushil. And Lordship, the police has also not explained why they have not apprehended this Lakshmi Rai, who was along with the accused. Lakshmi Rai was not mentioned by the IO, Lordship. Lordship. And then coming to PW9, Lordship, under Fukan, Lordship. On 2/12/89, I was at Difu PS. On that day, LC Nath of DCS informed OC Difu PS that injured victim Ganesh Thapa was admitted at Difu Civil Hospital on 28/11/89 and expired on 2/12/89 in connection of Difu PS number Iman. IPC under section 326 IPC, OC endorsed me to investigate the case. I conducted the inquest of the dead body of Ganesh Thapa in presence of witnesses. I found injury on the body of the victim on his belly where T-shaped stitch of operation was present. Also a wound. Also it could have been a wound on his waist. I examined the witness and sent dead body to DCH for PM exam. Exhibit 1 is the inquest report. Exhibit 1 is my signature. Then I made over my part of CD to Sri B. N. Das, IC Manja, IO of the case. In his cross-examination, he has stated, I examined witnesses at Defu Civil Hospital premises. The man found dead at hospital bed at 2 a.m. of 2/12/18. The victim was at hospital from 2011 to 2/12/18. Nothing as much, Lordship. There. Then, Lordship, PW10. He conducted the inquest, Lordship. Only the inquest. Now, Lordship, PW10, Ram Bahadur Shetty. I know the accused but don't know the informant. The occurrence took place about 30 years ago. He deposed in 2019, Lordship. 30 years ago. I don't remember the actual date of occurrence. Though I did not witness the murder myself. I heard from people that accused had killed the deceased. I did not go to see the dead body. Now, Lordship, in his cross-examination, he has stated that I came to know about this incident from my wife. Now, Lordship, this Ram Bahadur Chetri, as per his 161 statement, he was with PW7 and the deceased. It was found from the statement, page 51, paragraph 27. That one contact with the different thing. Now, Lordship, there are several contradictions in the PW, among the PW. PW10, as far as the court has stated this, Lord, as per his 161 statement, he was with PW7 and the deceased. Lordship. Now, in the witness, Lordship, he has completely denied the knowledge about the. He's just hears everything. No. Yes, yes. Yes, Lordship, 10 witnesses. I think P13, Lordship, the accused has denied as false every allegation that has been leveled against him. False. He has just stated in that he has been falsely implicated.
No, possible. Is it possible? Can it be taken up tomorrow? For about 3 years. 4, live, otherwise live. Kimona, private counsel, Rajbor Bhoya. I've not seen since morning. He is not here. No, sorry. May I leave?
I'm from the NIA.
Yes.
He's from the
Date
Now, Lordship, from the PWs, the statement of the PWs, no one has actually seen the occurrence of the incident, Lord. PW7, Lord. Yes. Now, Lordship, PW7, he has stated it was a dark night, distance of 15 meters. Because, Lordship, that part is not a city, Lordship, it's a village. Yes, yes, Lord. It was an evening, Lordship, in the month of November, Lord. Yes, Lord. Lordship. Lordship. Lordship, that is true, but also he has also stated. Yes, Lord. The judgment also, it has been recorded here that he did not see. He has stated that he did not. Lord, Lord. Lordship, that is why I am saying, Lordship, in the original this recording of the deposition, Lordship, something has been stuck out and no initial has been done. Lord. In case something, a word has to be stuck out, such a vital word, initial of the learned judge has to be there, or someone has to be there. Corrections, who made the corrections? When was the correction? Yes, Lordship. Yes, Lordship. Lordship, that may be so, but there is also another person, Lordship, Koila. Koila was not examined. Lakshmi Rai was there along with Sobilal. He was not examined. He passed away. But Lordship, in this case, Lordship, the evidence of Koila is also vital. Because PW7, Lordship, he has his deposition after 9 years, Lordship. Lordship, why Lakshmi Rai was not arrested, Lord? That is also a question. Because no, Lordship, it has been mentioned in the case. With the accused. Lordship. Lordship. Because Lordship, no, Lordship, but actually who step? Yes, Lord. Yes, Lordship. Lordship, and that is actually the Lordship, not a big deal. Yes, Lord. Yes, Lord. Yes, Lord. Yes, Lord. Yes, yes, Lordship. Basically, the witnesses know each other, but Lordship, as such, Lordship, nobody mentioned anything about PW7, Lordship, neither PW1, 2, or 3. Even Lordship PW7 stated that the Mon Bahadur was there with his son. Mon Bahadur is PW3 and his son is PW2. But they have also not mentioned PW7, Lordship. His cross is stated Rishi, Lordship. Rishi is the son of Mon Bahadur. Also, Lordship, PW7 stated that they took the deceased to the house of Karna Bahadur. Then from there on, the deceased went to Krishna Bandhu's house. But Lordship, PW4, who is the wife of Karna Bahadur, she has not stated that anyone was accompanying the deceased. And PW2, Lordship, PW2 and 3, they have stated that the deceased was lying on the road. Even PW1, he has stated. So, Lordship, the fact of the matter is that the PW4, PW1, they are contradicting themselves. In PW7, the presence of PW7s or his corroboration has not been stated, that nobody could confirm that he was actually with the deceased person at that time. So, Lordship, the scene of circumstances that there was no other explanation is actually not there, because there was someone along with PW7 and someone along with the accused, the appellant, Lordship. Although PW7 has stated, but his statements are also somewhere somewhat contradictory. I know the accused Sobilal of Manja. I do not know his residential address. I know that this is Ganesh Thapa. About 7 years back, in one evening, while I was going to Manja Bazar along with Koila, Ganesh Thapa, to have some refreshments, Sobilal, the accused, and one another followed us. When we reached near Karna Bahadur's residence, Ganesh Thapa went near Lakhi. So as per his statement, Lordship, Lakshmi Rai and the appellant, both of them followed us. When we reached Karna Bahadur is not Lordship, he is the informant. And then followed us. When we reached near Karna Bahadur's residence, Ganesh Thapa went nearby to pass urine. We were standing nearby. Ganesh Thapa was attacked by Sabilal after some altercation and was stabbed with a kupri on his illegible. He was taken to Karna Bahadur's residence. Then we tried to catch the accused, but he fled away. Then Ganesh Thapa went to Krishna Bahadur's residence, from where he was taken to Manja PH. And police was also informed. Police arrived. Then Sobilal was arrested. Yes, Lord. Yes. Yes, Lord. Yes, Lord. Yes. But he fled away, Lord. Krishna, Krishna. This went to, how come, Lordship? He stated went to. Either he was taken to. Yes, Lord. Yes, Lordship. PW1. PW1 has not mentioned. I think it's the same. I think, you know, Krishna. Yes. Sir.
Start. Fahad, son of Rabi Lal. Started Fahad and son of Rabi Lal. Page number. He's a one for the start.
Understand. Krishna Bahadur stated, Lordship, I know the accused, Ganesh Singh Tejas, came crying and fell down near my residence. Came and fell down near my residence. And Lordship, PW7 also stated that Mon Bahadur and his son were there. 2 and 3. PW7 has stated. Yeah. PW1 has also not stated anything about PW7, Lord. Neither has PW2 nor PW3. As per PW3, Lordship, and PW2, Ganesh Thapa was lying on the road with injury. From there on, PW2 took him to the police station, then to the hospital. Nothing, if one of my friends or someone is injured, I will naturally be with him. But Lordship, PW1, 2, 3, or 4, no one has stated anything that PW7 was with the deceased, Lordship. First of all, the Lordship, the doubt arises as to from where the deceased was taken to the hospital. Whether he was in someone's house or on the road or in Pranab Bahadur Shetty's house or in Krishna Bahadur Shetty's house, that is a fact. So, front of Pranab Bahadur Shetty, page number 8, PW8, taken as the incident took place in front of his residence. Page number 24. But our piece of questions, after that he went to Krishna Bahadur Giri's house. The police did not say anything about Krishna Bahadur Giri. And PW2 said that he was lying on the road. Lordship, the chain is not there actually. And Lordship, when two persons are there, and if three people are going together, when one is injured, it is the other two who generally take them to the hospital. If I and my friends are going somewhere, if one of my friends get injured, then generally I will take him to I or my friend. Lordship. Lordship. But actually, Lordship, no one. Lordship. It was a residential area, but Lordship still, none of the, I mean, PW has mentioned about anyone accompanying even the deceased. No one had seen, if it was a crowded area, then other people might have been there. It is not necessary everyone would be there in their home. No one had seen other than PW7 as stated by him, Lordship. If when PW7 has stated that altercation was happening, Lordship, if the altercation was happening nearly, it would have been raised a hue and cry. People would have come out. Lordship, one more fact is that the deceased was in the hospital for 4 days, 4 to 5 days, Lordship. There was ample time for the prosecution to get his statement recorded in a proper manner. But there is no explanation provided as to why his statement was not recorded in a proper and verified manner, Lord. Also, Lordship, this entire judgment is based on the consideration and an assumption that a dying declaration was made before PW1 and 4, and which was corroborated by PW7. As such, Lordship, PW7 has not been considered as an eyewitness. Lordship. Lordship. That is what I'm saying, Lordship. He was operated upon. That part I know, but nothing has been mentioned as he was in a fit position or he was not in a position to speak, Lord. Yes, Lord. Lord. No, Lordship, the police, the IO has stated that he went to the hospital and next day, and he talked with the deceased. PW 8, Lordship, page 24. Page 24, Lord. Page 24. Next day also. Yes. 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 Right. It was not done in presence of any doctor or any magistrate, Lord. There will be. Statement is not with. The IO also stated in his deposition that the wooden handle was in the of the cookie was in the hand of the accused. But the IO neither seized or neither exhibited. It's a vital piece of evidence, Lord. Now, Lordship, one more thing. The PW7 stated that when they tried to catch the appellant, he fled away. So, Lordship, then question arises, how did police find him with a handle in his hand? Cookie handle in his hand. If he had fled away, the police would not have been able to catch him then. Lord. But police did not examine any of the villagers who had allegedly apprehended the accused. Lord. Police did not examine them, nor were they listed as. Yes, Lord. Lord. As to who had apprehended him, Lordship, No mention has been made, either by PW7 or the police or the prosecution. Lordship. None of the person who actually allegedly apprehended the appellant has been made. If he had been apprehended by village, someone would have handed him over to the police. Police would have jotted down his name. PW8 23 Lordship. PW. Hmm. Hmm. Yes. That's the village people, Lordship. Just village people. No such witnesses has been examined. And why they only caught, the appellant, Lordship. Lakshmi Rai was also with him. That is also a fact of the matter, Lordship. Lordship. Then the cookie was seized. Seized without a handle, Lordship. That is the statement of police, Lordship. The appellant has denied all such allegations. Lordship, in his 313. Police has stated that they recovered the weapon, but the Lordship did not recover the handle, and they did not send the weapon to any FSL or any. Yes, Lord. Yes, Lord. Leading to discovery, Lordship. Yes, Lordship. I am reading. That is only the statement I have, Lordship. No other witnesses are there who said that it was the appellant who directed the police to the place of seizure. Lordship. 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 Yes, Lordship. It's nearby the place of occurrence, Lordship. So it's not necessary that the police might have taken might have searched and they found it. Yes, there is also a possibility. Lord. Lord. Literally. Yes, Lord.
dead and not
Bal Bahadur, I mean, no lordship, not this. Procedurally, actually does not state that it was recovered on basis of the input provided by the appellant lord. Lordship, neither was such statement. Mon Bahadur has been examined, lord. Mon Bahadur. Lordship, PW3, Mon Bahadur, he stated that Ganesh Bahadur took to hospital and Sabilal was taken to Thana by police from PO. From the PO, my son Rishi Bahadur Gante took Ganesh to hospital. Kukri was recovered from a distance from the place of occurrence. They have not, by that time, they had already taken him to the police station. So, any such statement by the appellant, he had actually given to the police that we have thrown the Kukri therein, it has not been stated. And also, Lordship Bal Bahadur, who was a signatory to the seizure list, he has also not been examined. Page 70, Lord. 70. Finish.
that like type.
Nothing, Lordship. The EW7, he had stated that altercation had occurred between the appellant and the deceased lord. If they had heard the altercation, they would have tried to stop him, tried to intervene or something like that. not like just you are saying, I'm just saying having altercation and suddenly I'm will stab him. Yes, Lord. That's the thing, Lord. Yes, Lord. 15 meters. Yes, Lord. That is what I'm stating, Lord. 15 meters in November during evening time. And altercation is generally, Lordship, loud noises. And there were two persons, him and Koila. Lordship. Lordship. Yes, Lord. Lord. Lordship. There is nothing as such on the record, Lordship. And in fact, there is also nothing to suggest that actually Ganesh Thapa and Sabilal had some kind of animosity earlier also. There is also Lordship. 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 Might have been tutored by the family members of the deceased, Lordship. That might be a possibility because he is a daily laborer. That is a question, Lordship. But Lordship. But family members of this, they were actually Lordship, family members were, I mean, they were examined. Rishi Bahadur Shetty is a family member of relative of this, Ganesh Thapa. Even he was examined. He also did not say anything about. No, Lordship. No, Lordship. They were not even listed as witness or anyone. And Lordship, the deposition took place after 9 years, nearly about 10 years. But he had stated that the incident occurs about 7 years back. Yes, Lord. Yes, Lord. We see maybe. I know Sabilal Setri, I know Ganesh Thapa. He says that he knows Ganesh Thapa. The thing is, Lordship, the on. Hmm. PW5 का एक बाकी तो क्वेश्चन है Mon Bahadur he is not I don't think they are related যেনে কৃষ্ণ বাহাদুৰ গিৰি to কৃষ্ণ বন্ধু গিৰি to in the paragraph page 51 not well, it is also found it is found on the statement of Rambaru state paper under 161 services he was with PW7 and at the time of occurrence but his evidence shows that he was not with PW7 at the time of occurrence. It is as per his 161 statement Lord, but it also casts exasperations on the statement of PW7 Lord, because PW7 has not stated anything about Rambahar. Lordship, what I can make out from this paragraph 18 and paragraph 51 is that the 161 statements of PW7 and PW10 were nearly identical. However, PW7 in his, deposition, he deposed something totally opposite. Lordship in it also begs the question if they, as per stated by the IO, if they recovered the kukri on the basis of the inputs provided by the appellant, why they did not recover the handle? Not true, Lordship. They had actually, Lordship, nothing could be linked that the machete or the kukri was wielded actually by the appellant. Because the kukri also, no test was conducted, Lordship, FSL. And Lordship, handle the fingerprints upon them were not also, subjected to any test or link actually with the appellant. Lordship. Hmm. No, Lordship. Because seizure list, as a two seizure list. This is one key. One is the complete case map. No, Lord. No, Lordship, please have a look at page, page 67 of the list, name of identifying police officer and the relations of the deceased accompanying the court. Details on the receive page 67. Relations of the deceased. Rishi Bahadur and Kamal Seth. Lordship, page 67, Lordship. Page 67, Lordship. Name of identifying police officer and the relations of the deceased accompanying the court. Jiten Chandra Bora, Rishi Bahadur Setri and Kamal Setri, Lord. So Rishi Bahadur Setri is a relative of the deceased, Lord. Since otherwise it would not have been recorded as relations of the deceased. Yes, Lord. Yes, Lord. That is what I am saying, Lordship. If any dying declaration was made as such, then Rishi Bahadur Setri was might also have visited. Yes, Lord. Yes, Lord. Lordship. Yes. Hmm. Longest time, Lord. Yes. Yes. And he picked him up from the road, Lordship. He was lying on the road. Lord. Cool.
But the eyewitness, PW7, the main problem is whether he is at all believable. And ocular witness will of course supersede other witnesses. Now, in order to believe him, Lordship has to see whether his statements makes out a ring of truth, as the Honorable Supreme Court has said. Now, ring of truth, in order to find that, Lordship has to appreciate, scrutinize his evidence. Now, here, PW number 7, he is the sole eyewitness, as it seems. And then he said, in a very short and precise way, not even a very long statement, very short and precise, he said, I with Kaila and the deceased went to the market to have some refreshment. Then, when we reached the house of PW4's husband, that is Karna Bahadur's residence, deceased went to ease himself out. Then he saw the accused person coming there. And in fact, he said accused and another were following them initially. Then he came, he went near the deceased, had an altercation, and thereafter he gave a stab wound on his belly. And there is nothing to disbelieve as such. He's very straight in saying this. Thereafter, deceased was taken to the house of the Karna Bahadur. That taken, Lordship will see some part of here and there will be there. That in fact brings truthfulness. He was taken. Now, perhaps he was taken, the wife of Karna Bahadur had not seen them. And then they tried to nab the accused person. And in the meantime, he himself went to, Lordship said he was again taken to. What I find is they chased him, went to nab the accused. And then he himself went to the house of PW1. And the deceased. This is what is Coming, Lordship will see page 21, last line. Then we tried to catch the accused, but he fled away. So that means they were chasing him. Then Ganesh Thapa went to Krishna Bahadur's residence, from where he was taken to the hospital and police station. So he himself went. That is corroborated by 1 and 4. That is Karna Bahadur's wife. PW4 is Karna Bahadur's wife. She said she was in her house with her children, and then Ganesh Lama came to my residence. That is in fact corroborating. They were taken. She might not have stated about the other persons. No. Karna Bahadur's wife is he passed her. Yes. His wife. 4. She said Ganesh Lama came to my residence with physical injuries on his person and lied on my premises. He seldom talked at that moment. On being asked, he told that Chabilal cut him. This, in fact, deceased going to their place is corroborated by PW4. And then the oral dying declaration. This oral dying declaration is there. Then I shouted, people of the locality assembled. Public arrested Chabilal and took him to Khana. So people of the locality assembled. There were so many people, so they came. Injured Ganesh Lama was removed to hospital by police. Bal Bahadur and my husband, this is Karna Bahadur, informant, was dead. So this is an oral dying declaration. PW7, whatever he said is corroborated by her. He went to Karna Bahadur's house. Karna Bahadur's wife said, yes, he came to my premises. And these are the dying declarations. Then PW1, then PW7 said that when we tried to nab the accused person, he went to PW1's house. So PW1 also corroborated. PW1 said he came crying and fell down near my house. I went there and saw Ganesh with injuries. Yes. 4. Yes. He went. Gone. Thereafter, he was taken to Thana, Rishi says. So, in fact, the entire case is, in my humble submission, is made out. In fact, how to gauge a oral dying the ocular evidence. There is a beautiful judgment I have given out, paragraph 7. I have just taken out that relevant para. The Supreme Court has said how to appreciate an ocular evidence. So some discrepancies will remain. That is what Honorable Supreme Court said. Lordship will see paragraph 27. The appreciation of ocular evidence is a hard task. This is, Lordship will see, this is SCC. This is I've taken out from Manupatra. But this is reported in SCC also. Shahaja versus State of Maharashtra. SCC is not given here. Lordship said INS. And I'm not aware of. INS. That I'm not aware of, this journal. INSC. Acha. Oh. Online it is available. Oh, that's a nice thing. Lordship will go to paragraph 27. The appreciation of Lordship got it. Shahaja. Yes, State of Maharashtra. Paragraph 27. The appreciation of ocular evidence is a hard task. This is how it starts. There is no fixed or straitjacket formula for appreciation of the ocular evidence. The judicially evolved principles for appreciation of ocular evidence in a criminal case can be enumerated as under? There are so many, in fact. One, while appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence, more particularly keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence as a whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witness, and whether the earlier evaluation of the evidence is shaken as to render it unworthy of belief. If the court before whom the witness gives evidence had the opportunity to form the opinion about the general tenor of evidence given by the witness, the appellate court, which had not this benefit, will have to attach due weight to the appreciation of evidence by the trial court. And unless there are reasons weighty and formidable, it would not be proper to reject the evidence on the ground of minor variations or infirmities in the matter of trivial detail. 3. When eyewitness is examined at length, it is quite possible for him to make some discrepancy. But court should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible with the credibility of his version that the court is justified in jettisoning his evidence. 4. Minor discrepancies on trivial matters not touching the core of the case. Hyper-technical approach by taking sentences torn out of context here or there from the evidence, attaching importance to some technical error committed by the investigating officer, not going to the root of the matter would not ordinarily permit rejection of the evidence as a whole. 5. Too serious a view to be adopted or mere variations falling in the narration of an incident, either as between the evidence of two witnesses or as between statement of the same witness, is an unrealistic approach for judicial scrutiny. 5. By and large, a witness cannot be expected to possess a photographic memory and to recall the details of an incident. It is not as if a videotape is replayed on the mental screen. Ordinarily, it so happens that a witness is overtaken by events. The witness could not have anticipated the occurrence, which so happen has an element of surprise. The mental faculties, therefore, cannot be expected to be attuned to absorb the details. Now, not saying that he had also come will be included here. The powers of observation differ from person to person. What one may notice, another may not. An object or movement might emboss its image on one person's mind, whereas it might go unnoticed on the part of others. This is in case of when there are two or more witnesses. 9. By and large, people cannot accurately recall a conversation and reproduce the very words used by them or heard by them. They can only recall the main purport of the conversation. It is unrealistic to expect a witness to be a human tape recorder. In regard to exact time of an incident or the time duration of an occurrence, usually people make their estimates by guesswork on the spur of the moment at the time of interrogation, and one cannot expect people to make very precise or reliable estimates in such matters. Again, it depends on the time sense of individual, which varies from person to person. 11. Ordinarily, a witness cannot be expected to recall accurately the sequence of events which take place in rapid succession or in a short time span. A witness is liable to get confused or mixed up when interrogated later on. 12. A witness, though wholly truthful, is liable to be overawed by the court atmosphere and the piercing cross-examination by the counsel, and out of nervousness mix up facts, get confused regarding sequence of events, or fill up details from imagination on the spur of the moment. The subconscious mind of the witness sometimes so operates on account of the fear of looking foolish or being disbelieved, though the witness is given a truthful and honest account of the occurrence witnessed by him. A former statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction, unless the former statement has the potency to discredit the later statement. Even if the later statement is at variance with the former, to some extent, it would not be helpful to contradict the witness. Now, my learned friend is also saying that he has said this and that in 161. This has not been brought on record. He is not neither made hostile, nor he was contradicted with those statements. So those statement goes.
Those will
Goes.
not have
Yes,
relevance.
we will be saddled only with the statement given.
No,
before the trial.
whatever advantage he had to take, what is the stage of the trial? Confront the witness with 161
Yes,
and say that this is not what you have stated
Uh-huh.
to the police.
contradicted.
Now, contradicted. Now that stage is over.
Over. Nothing has been done. So we are only with the statement before the trial court. So this statement, as your lordship had also seen the cross-examination part. Now he said that it is, I did not see who had stabbed. This is not the case here. He saw. He saw who had stabbed. He did not speak about Lokhi or the other person. Straight away, he very clearly stated about Shabilal. He attacked. Maybe there was another person with him, but he is not in the picture. Neither he said that the other person had done something. He clearly said it was Shabilal who attacked and assaulted accused, the deceased. So cross-examination, it is not demolished. His statement stays, coupled with the dying declarations, the oral dying declarations. So my submission is that this is enough to bring home the guilt. The other part, that the police's statement that he did not record the dying declarations and all. He was alive for 4-5 days.
He passed away on 3rd.
Third, and he was able to speak initially, but when he was taken to Diffu Civil Hospital, he was unable to speak. He was not in his sense. But then on the next day, police, when he went to take a statement, he said that the Shabilal has attacked him. 161, in fact, 161 of a deceased person can be taken as a dying declaration. That judgment, there are so many, I don't have it today. 161 of the deceased person can be taken as a dying declaration. The part can be taken. So he had stated before the police that he was attacked by Shabilal. And that handle, of course, handle was not seized. And the kukuri was bloodstained. In the Caesar list, it is written bloodstain without the handle.
Blood and soil.
Blood and soil. Stained with blood. And soil is, oh yes,
Soil is-
stained with blood and soil. Its length is 18 inches, does not have a handle. That also corroborates. He was arrested with the handle. Handle was not seized. But kukuri was without the handle, the one which is seized. A part of the kukuri measuring 6 inches is stained with blood. So 6 inches, the front part is stained with blood. And then Lordship is correct in saying PW 2 and 4. He said that Rishi was the better person before whom a dying declaration could have been made. But Rishi came to the picture late. He was in the house, he heard hue and cry, he came out and then he saw the person lying injured. He took him to the hospital. By the time he became unconscious, he could not speak.
But what, while just before you had completed the earlier part, that he had also made a statement on the next day before the police, which can also be taken as a dying declaration. Because ultimately dying declaration, whomever it may be made, it has a different degree of its veracity. But what about the aspect that no attempt was made to get his statement recorded in a proper manner by calling
That is
by the doctor before the doctor or a magistrate?
That of
from
course.
20 till third he had passed away. There is nothing on record to know what was his actual stage. The police officer no doubt says that on the next day when he had gone, he had implicated the appellant. But there is nothing on record to show was his health condition, whether he's in a position to. In fact, we have seen somewhere that no attempt was made to record his statement.
Yes, that ploy is there. That I have Supreme Court judgment saying that
PW7, I think.
some explanation should be here forthcoming why his statement was not recorded. I'll go to PW 8 statement again. He said that no prayer was made for dying declaration. Lordship will see the cross-examination.
Yes,
No prayer was made for dying declaration.
yes, that is what we are trying.
This is what he said.
Yes.
Of course, the first statement is I did not record the statement of first informer. No prayer for dying declaration. Dying declaration, whether he meant of first informer or the deceased, that is difficult to say.
No, no, dying declaration has to be of the deceased.
Deceased only.
Deceased. Word informer is not died out of
Yes.
any offense.
Yes. It's a normal death. No prayer was made for any dying declaration. It is he who should have made prayer for dying
What
declaration.
about the handle of the cookery not seized? No FSL done.
That, of course, that flaw is there. But in view of the
Even to the extent of no FSL being done, so for fingerprints, seizing of the handle from his hand, because he says in very clear terms, it was in his hand. The handleless cookery was found somewhere else, but the handle was found in his hand. How the handle went off, we do not know.
He said, I did not seize. It is not a fact that he said that I did not seize handle of cookery said to have been found in the hands of the said to have been found in the hands of the accused. Now, those flaws are of course there. He should have given it for, he should have seized the handle that should have been connected with the part of the cookery, sent for the FSL. Those flaws are there. But in view of the eyewitness, because those are technical evidence, those are scientific evidence. Now, in view of the eyewitness who had stated, who was there when the accused was attacked, these evidence comes to the backward.
Eyewitness Sushil,
Sushil,
PW7.
PW7. His only, my learned friend's only submission is that it is demolished in his cross-examination by saying that this line, which even the trial court said that he did not see who had actually stabbed the accused. But as a matter of fact, Lordship has checked the lower court records, there is correction, and it is the fact that he had seen who had stabbed. 5:30 of this time, this is November, the same time now we are
Mr.
having.
Das has also made another submission that this PW7 has clearly mentioned Mon Bahadur and his son, Rishi, that means. But neither Mon Bahadur nor Rishi had even made a passing remark about the presence of PW7, who has turned out to be a very vital witness.
No, what PW7 said that he was with Kaila. Kaila was not examined.
No. PW7 says that Mon Bahadur and his son Rishi were also present.
No, Lordship says subject to correction.
Yes.
This is what PW1 said.
No. Come to page 21.
Achha. PW7, I'll read out again.
Yes.
I know accused Sabilal of Manja. I do not know his residential address.
Last sentence of cross.
Last sentence of cross.
Mon Bahadur with his son.
With his son.
And 10 to 20 people also assembled. He clearly mentions Mon Bahadur and his son. Son means Rishi.
Mon Bahadur.
Mon Bahadur also examined, Rishi also examined. Neither of them has even made a passing reference about the presence of this vital PW7.
Mon Bahadur with his son and 10-12 people assembled there.
10-12, okay, he has not named. Mon Bahadur and Rishi becomes important because they have not only been named, they have also been cited as witness, deposed.
Yes, 2 and 3, I think.
3 is Rishi, and 3 is his father, Mon Bahadur.
No, 4, oh yes.
2 and 3.
2
is
yes,
Rishi.
yes, 2 and 3. 2 and 3 are son and the father.
Yes.
But what he said, Mon Bahadur with his son and assembled, that is after the occurrence. After the occurrence, they in fact reached. Not at the time of the occurrence.
No, after the occurrence. Because Mon Bahadur and Rishi did not claim of witnessing the. But Mon Bahadur and Rishi did not even say that PW7 was there or it was.
No, in fact, let us go to PW2. He said people had assembled. I was milking so and so. I was many people gathered there. So many people he did not specifically name. Many people gathered there. When he came out, he saw Ganesh Thapa lying with injuries on his belly on the main road. Many people gathered there. Then they took Thapa to Thana. It is later at the point of time. And again in his cross, he said, many people assembled. On my arrival, I saw 20 persons there. Ganesh Rabha Thapa was properly dressed. Kante
He-
went
He stays at a furlong, more than a furlong.
more than a furlong. Furlong is 12 feet or something.
No,
Oh,
furlong is more.
more. One furlong is
Might not be technical, but
yeah, this is their her relative, they use it that way, no? Into any kiman, furlong.
এটা বহুত broad.
200 meters. Furlong is not far, not near.
Oh,
200 meters.
200 meters. Not very far out. 100 meters.
Not very near also, and it
Huh.
so it gives that he took some time to come from his home. By that time, many things have
Happened.
happened.
Because he was urinating, he was attacked. He ran to PW4's house.
No, this is Rishi.
No.
He was in his house.
Huh.
He heard some sound. Then from 200 meters he comes. By that time, everything is over.
Everything was over. And he was lying on the road. By that time, he was running here and there. Running means somehow from the place of occurrence to somebody's house, then to somebody's house. Then he lied on the main road. But one thing is there, of course, 4 or 5 days he was alive. And the matter was first registered under 326 only. Later on, 302 was
302
added.
was added.
But I have few decisions where it is said 302 can be converted into 326 if a person dies many days later.
No, here proximity is very less. 4 days, 5
4
days.
5 days.
And
The
it,
judge,
it was directly as a result of this injury.
my judgment I have was of a month. After a month, he died.
No, this thing has to be examined from the nature of the weapon used. Had it been a lathi blow or maybe complicated, he died. It's by a kukri and that too in the stomach, abdomen. 2 blows.
2 blows. This is what lungs and the
Vital aspect. Lungs
Liver.
and lungs and liver.
lungs and liver,
Vital organs.
vital organ. And he came with an intention. He was following them. Carrying a kukri, of course, can be a normal thing for a villager, but such a long kukri, 18 inches. And that too, he was following with another person. And there was an altercation. Few of them said that there was an altercation. But one altercation is hearsay. One person, he said about altercation. That is, he heard, but the PW7 said about altercation. How altercation would I continue? PW5 said about altercation. Lot.
See, madam, this Kaila
Hmm.
and Til Bahadur Chetri have not been examined.
Hmm.
There is no gain, will not gain anything by asking why they are not examined. You'll
Hmm.
not be in a position to answer.
In the charge sheet,
No,
there
no,
were more
No,
witnesses.
no,
but-
you'll not be able to answer because what has been done is done. But we have to see the consequences.
Hmm.
Whether their non-production would have aided to the defense
Hmm.
in any manner.
Hmm.
And their non-production has affected your case, if you can address on that.
No, sometimes non-examination of important witnesses can shake a case, but
Yes, no, no, how important this Kaila and Til
Huh.
Bahadur will be?
because they will be at the same parlance because PW7 said we were together, me and Kaila
Kaila
were together. Til Bahadur had informed.
informed, yes.
Maybe he's in hearsay, he heard and he informed. But
Til Bahadur
Kaila
cannot be a very relevant witness because thereafter the formal Azahar was taken from this
taken
PW,
place and all.
the husband of PW 4.
Four, he said. So main evidence would be Kaila. So Kaila and this PW7 will be at the same parlance, same person. They were together. They
We
have
will
seen.
not examining Kaila will affect the case of the prosecution to that extent that we cannot believe PW7.
Because PW7 is also an eyewitness. Kaila would be also an eyewitness. PW7 had said these. So in cases of very weak nature, Lordship can say that yes, examination of this witness is fatal. But here there is a strong evidence, and PW7 had stated what he had seen. Kaila would have also have stated. Now, what happened to Kaila, we don't know. But non-examination of Kaila will not be fatal in view of PW7 statement. One ocular evidence is enough. Coupled with corroborations from the dying declaration.
We'll come to it.
Dying declarations can become the sole basis of conviction. Oral dying declaration coupled with corroboration. Now here I'm taking oral dying declaration corroborating the eyewitness. Had there been only eyewitness, Lordship could have concluded that non-examination of the other witness is somewhat making some sort of difference. But here there are corroboration. There is no animosity. Why will 1 and 4 go against the accused? Kaila Lakhiram আছে Kaila বা তার ভাল নাম কি? Lakhi to was with you. Was with you. কিন্তু কায়দা আছে কায়দা ভালো same. Kaila will known by some other name. (161) statement of the PW7 can be seen once. I'll just say 161 of PW7 once, if Kyla had some other name and all.
Doesn't appear
Uh,
from the charge sheet.
One Lucky Ram is
No, Lucky,
expired.
that is different. It's GD entry.
Acha. No, GDN says
Otil
Chil
Bahadur.
Bahadur. But Lucky Ram, number 11 in charge sheet, he expired. But it would be
We had a reference of Lucky Ram here.
Lucky Ram was
judgment.
with the appellant court.
With the
Lucky Ram was with the appellant court. Now, Lordship, as per, if we go as per this assumption, there are three vital witnesses, eyewitnesses, Lord. Koila, Lucky Ram, and PW7. Out of those, only one has been examined. One has already passed away and other could not be found, Lord. Now, if we go to
Who has passed away?
Lucky Rai, Lord.
Lucky Rai has
Lucky Rai has passed away.
11, number 11.
Number 11, Lucky Rai has passed away. Lucky Rai could not be examined, Koila could not be examined. And Lordship, if we go to the deposition of PW4, Lordship.
Yeah.
Now here, she has stated that I know the person that I know the also complaint, Lordship. Nor Bahadur, Dol Bahadur was present and none else at that time. He specifically named two persons.
No, this we have read and reread. You have to read this cross along with the chief.
Yes, Lord.
See, chief, she says about 2%.
Yes.
Bal Bahadur
And my husband.
that is Korna Bahadur.
Yes, Lord.
Then was the question, the recording, we cannot, whatever has been there is there.
Yes, Lord.
In the cross-examination, she names two more and no more and no none.
Yes, Lord. So her deposition is itself doubtful, Lord. Once she has stated her husband and Bal Bahadur, then on her cross-examination, she has stated Nor Bahadur and Dor Bahadur. And also, Lordship, she has
Thereafter, he says none else.
None else, Lord.
It means 4 persons. It was at that time before separation.
Yes.
Everything we have to.
Yes, Lordship.
But it is a fact that you should get, if some benefit is to be given to you, you should get the benefit. But you should read as a whole.
Yes, Lord.
Chief, it's not that in the cross he said, no, my husband was not present. It's a wrong statement. He said the overall meaning would be Korna Bahadur, Bal Bahadur, Nor Bahadur, Dol Bahadur. Thereafter, nobody.
Yes, Lord.
They were all there.
Lordship, in her chief, she also stated, on being asked, he told that Sabilal cut him. So she has not said that the deceased had told her that Sabilal not directly to her. It's not clear whether the deceased had made this statement directly to her or to her husband or to the other person standing there.
On being asked.
Yes,
whoever
Lord.
asked.
On being asked. He did not say that I asked him. On being asked. Who had asked him?
Maybe husband
See,
had
so
asked,
from
but
the sequence of events,
Lordship.
the PW7's
Lordship.
eyewitness, he was with the deceased.
Lordship.
So what he has seen and what he has deposed from
Lordship.
is the first sequence of events.
Lordship.
The role of PW4 or PW2 came later.
later.
In the meantime, something has happened.
Lordship, then if we
So
go
it
to
it will not be fatal if PW4 or 2 does not make a mention about PW7.
Lordship.
Doesn't
Because-
because they
because-
came later.
It's not that not mentioning. They said that people had gathered. If amongst them PW7 was there, it is not a very doubtful kind of a postulate. It can be accepted.
Lordship. Now, Lordship, if we go to the deposition PW7, Lordship,
Yes.
he has stated that Sabilal and one other followed him. Actually, Lordship, in his entire deposition, he has not said that. Actually, it was Sabilal who was carrying the cookie.
No, he saw that stabbing by
Yes,
Sabilal.
he was stabbing, but Lordship, in fact, if we go to there, it was a dark night and there was, and also if we contradict it with the deposition, actual deposition, Lordship, which the judgment had taken that he did not see. So it raises credibility issues about the deposition, Lordship, quality of the deposition. And Lordship, there is nothing, in fact, if we see, then the PW7 has stated that the accused fled from there. So will the accused flee from there and carry the handle with him? As per the statement of PWA. Why will you carry the handle with him? There is nothing, in fact, linking the murder weapon to the accused, Lordship. I mean, to the appellant.
No, he had carried the kukri itself,
No, no.
but then on the way, that kukri fell
That
down. And
yes, he had carried the cookie. That has been not been stated by PW7 or anybody else.
he said he fled away.
He said that he fled away. He did not say he fled away carrying the cookie or the handle. And if a person flees away, Lordship, why will you carry the handle along with him? He will throw it the first chance that he gets.
161 is very difficult to read. I cannot.
And Lordship also, Lordship, the original deposition, the corrections which has been done. No initial, nothing, Lordship. And on the judgment, it has been recorded, he stated that he did not see. So the credibility and veracity of this deposition is in question, Lordship. Can we actually go by this? Because any benefit of doubt goes to the appellant, Lordship. In fact, Lordship, one more thing, Lordship, this deposition is done after 9 years, after 9 to 10 years. And still, if the PW7 remembers the name of Mon Bahadur and his son, but Lordship, Mon Bahadur and his son, they were examined after 4 to 5 years. They did not say. And he himself stated that he came from far along. If we go by that statement, Lordship, then the PW7 was with the deceased till Mon Bahadur and his son Rishi Bahadur got there. And they got there after
Mon
quite some
Bahadur,
time.
Rishi Bahadur says that they had seen many people gathering.
Yes,
there.
Lordship, but that contradicts the statement of PW4, who says that only 4 persons were there. So either we believe PW4 or we believe PW1, PW7 or PW3. 2.
But in her chief, she said, I shouted, people of the locality assemble.
Yes,
Let us see in what context the presence of these 4 persons have been said.
Lordship.
Page 14.
Yes, I know the person talk now. I also know the complainant, my husband, since deceased. Purna Bahadur Setri. About 4 years ago at 6 p.m. I was at home with my children. Sri Ganesh Lama came to my residence with injury on his person and lied on my premises. He seldom talked at that moment. On being asked, he told us Sabilal cut him. I shouted, people of the locality assembled. Public arrested Sabilal and took him to Thana. Injured Ganesh Lama was also removed to hospital by police. Bal Bahadur and my husband was present at that time. After 5 days, Ganesh Papa died in hospital. I had not seen the occurrence at the spot. Nor Bahadur, Dol Bahadur was present. None else at that time.
What time?
At that time.
At that time.
Which
At which time, Lordship? That's also
It
quite
was
important question.
during occurrence.
During occurrence, maybe.
During occurrence, because in chief he said, I shouted, people of the locality assembled.
Yes,
This time has to be read at the time when the actual occurrence had taken place.
yes, Lord.
Not during the time this deceased had come to their house. She shouts, people, they assemble. And at that time of the occurrence, Bal Bahadur and husband were there, and also this Nor Bahadur and Dol Bahadur.
It was in the evening. And Lordship, if people of locality
and
had
the persons named above heard the statement of
this
Ganesh. These
Time
4.
declared.
in this court.
My husband said there is child. My husband asked Ganesh about the incident. It is my husband, they died 1 year, my husband. It is not a fact, I did not ask him. People arrested Chabila, I am not going. I was not going to arrest it. I was not told to anybody. I was not told by anybody. I heard about the arrest.
I heard about Sabilal through Halla. So she came to know about Sabilal through Halla.
No,
No.
arrest.
Arrest.
Oh, yes. Oh,
Arrest.
sorry. Oh. So, Lordship, if after her shouting, the people of the locality assemble, as per PW7, he was already there. From the time of occurrence till Rishi Bahadur arrived. So, why she did not mention him or PW1? If PW7 knew Mon Bahadur and his son, they might have also known him. There is ample chance.
মই আর পার করতে
Wheeler.
Seven also claims that he had tried to nab thee and ran after him.
Yes.
So immediately after the incident, after his witnessing the incident, whether he was also there when this person had met the deceased in this condition, because he went after the deceased.
Went after this.
That has come on evidence.
After going to Korna Bahadur's house.
Lordship, regarding this recording of dying declaration by the police, I have a judgment, Lordship. Sanjeev Mura.
Here there is no dying declaration. We are not relying on the dying declaration of the police.
Lord.
And do you have any citation on dying declaration as such that this dying declaration allegedly made before PW 4 and PW 1 are not, cannot be relied upon?
Lordship, there are a number of judgments, Lordship, regarding it. First and foremost is the state of mind.
Please.
No, the settled principle is oral dying declaration. Prudence requires that it should be corroborated. This is oral dying.
Manjunath and others. Manjunath too. Lordship, it. Murati, yeah. Lordship, page Manjunath and others, for state of Karnataka. Page 11, Lordship.
Just a minute. Trial court has proceeded with the presumption wherein the cross-examination is that he has not seen. Which is this case? Sanjeev Mura?
No, Lordship, Manjunath. Another case.
You have given
Sanjeev Mura is regarding this dying declaration recorded by police, Lord.
No, you have given Sanjeev Mura to us.
Manjunath. Which one?
Can you give the citation?
Lordship, it's SC Crimes 2023, volume 4, page 202.
Any other citation?
20230 INSC 978.
INSC is there. Yes, which para?
Lordship. I'm starting from page 11, Lordship, paragraph 15, 1.5.2. On a similar note.
Page 11.
It's as per this, Lordship, paragraph number 11.51. On similar note, this court in Paneerselvam versus State of TN observed, though a dying declaration is entitled to great weight, it is worthwhile to note that accused has no power of cross-examination.
11.5.2.
Yes, Lordship.
Okay.
Has no power of cross-examination. such a power is essential for eliciting the truth as an obligation of oath would be. It is the reason the court also insists that the dying declaration should be of such nature as to inspire full confidence of the court in its correctness. Then, next paragraph, Lordship. However, a note of caution has also been sounded. If a declaration does not inspire confidence in the mind of the court, that is, there exist doubts about the correctness and genuineness thereof, it should not be acted upon in absence of corroborative evidence. Now, Lordship, I am coming to paragraph 11.6. The court must be satisfied that at time of making such a statement, the deceased was in a fit state of mind. In Shama versus State of Haryana, a fit state of mind has been held to be a prerequisite alongside the ability to recollect the situation and the state of affairs at that point in time in relation to the incident to the satisfaction of the court. Now, Lordship, if I may state, Lordship, PW4 has stated in evidence that when the deceased arrived at her place, he seldom talked. Then PW2, he stated that the deceased was nearly senseless. So, Lordship, at that time, what was the state of mind? Was he in a fit state of mind to make any declaration? That raises the question. And Lordship, PW1, before PW1, he has also not stated clearly that it was Sabila. That also raises the question because he came and, as per him, he came and fell down near his house. While PW4 stated that deceased was resting in her house. After that, he was taken to the hospital. While PW2 and P stated that he was lying on the road. So let's say if he was lying on the road, then other than his mental condition, it would not been strong. I mean, he would not be in a fit mental condition to make any declaration. And it was not on his halabu that the person said get Lordship, and that's the thing. I am reading paragraph 11.6.2. In order to make a determination of the state of mind of the person making dying declaration, the court ordinarily relies on medical evidence. However, equally, it has been held that if the witness is present while statement is being made, state that the deceased while making the statement was in a fit state of mind, such statement would prevail over medical evidence. The statement of witnesses present prevailing over opinion of doctor has been reiterated. So, Lordship, the witnesses present, none of them has stated that he was in a physical fit state of mind. PW4 stated that he seldom talked. That means he was in shock. PW2, who took him to the hospital, he also stated that he was nearly in a senseless condition and he did not utter anything or take anyone's name. So, Lordship, it raises condition upon the fitness of the mind of the deceased at the time of the incident when he was making the alleged dying declaration. After that, Lordship, 4 days had already passed. Police had gone there. If they wanted, they could have taken a proper dying declaration, not a dying declaration, the statement in presence of a doctor or a magistrate. And regarding the corroboration, Lordship, of PW7.
Yes.
Now, I know the accused Sabilal of Manja. I do not know it. I know that this is Ganesh Thapa. I was 7 years while I was going to Manja with Koila, Ganesh Thapa to have some evidence. Sabilal accused and another one followed up. Lordship, the another one, Lucky Rai, he does not say which one of them carried the cook. He said that he had stabbed. He saw the accused stab the deceased. But in his cross-examination, he negates the same. And in the judgment, it has also been recorded as such. And then, Lordship, he states that he was taken to the house of Governor Bahadur Sethi. While PW4.
See, who carried the cookery? Will it be so material?
Lordship, it does. Because actually, Lordship, there is nothing as such. Otherwise, if we go by the statement of PW7, who stated that he saw the accused stab the deceased.
Just a minute.
Because as such, Lordship, there is no motive. I do not know, PW7 stated, I do not know whether there was any bad blood between them. There was no motive for the appellant to stab the deceased. There was an altercation as per PW7, Lordship. But none of the other witnesses stated they do not know, they have known anything about such earlier animosity. Even Rishi Bahadur, Lordship. He knows both the accused and the deceased. No motive will be imputed. And also, Lordship, the Kukri has not been linked other than this fact. If we go by this, that he saw, PW7 saw the accused stab the deceased, there is nothing linking the accused to the Kukri, Lordship. The handle was not recovered, his fingerprints were not taken. And Lordship, as per PW7, he was with him till Mohan Bahadur and Rishi Bahadur came. And they came after such a later time. Yes, Lordship. 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 Yes. Yes, Lordship, but he has denied that he has seen who has stabbed the deceased. Lordship. Not as per the judgment, Lordship. Lordship. Lordship.
To the dying declaration part more than the ocular evidence.
Lordship.
Normally, ocular evidence, if it is there, you hardly go to a dying declaration. Here it is only for that reason that knot was there.
Right.
Knot has been cut and there is no endorsement. You are right in that.
And Lordship, so as if we go for a dying declaration, Lordship, PW4 has stated that the deceased was taken from her place to the hospital. Even the police has stated. Even the IO has stated that the deceased was taken from the front of residence of Karna Bahadur Setri to the hospital. Now, Lordship, as per Krishna Bandhugiri, Krishna Bahadur Giri, the deceased came and fell near his residence. So, Lordship, both the statements, they are contradictory.
No, that part, we will consider that part has been tried to be explained by Ms. Jahan. We'll definitely will consider.
And Lordship, as per Rishi, who took him to the hospital,
Yes.
the deceased was lying on the road, not in front of anyone's house or inside anyone's house, on the road, Lord. And he did not say that it was near Karna Bahadur's place or Krishna Bahadur Giri's place. That has also has to be taken into consideration, Lordship.
Okay.
Yeah, I did. Who did stabbed?
Yeah, okay, I can not be.
Oh,
It was also अपनी करते हैं, but yeah. FBI report. In fact, Lordship,
There are some other corrections also.
Lordship.
Not there is no endorsement.
no endorsement, Lordship. That is
Not only not. You see, there are other corrections also.
Stabbed.
Corrections.
Village
Yes.
residents be able to recognize. Yes, correct. Here,
And in fact, Lordship,
other evidence.
PW7 is an illiterate person. He could not have read it himself. So, Lordship, was he sure that he knew what was being recorded?
How do you say he is illiterate?
Because he has enacted some impression. He has not signed, Lord.
Let's see. How is it stated?
He is a daily laborer, Lordship. So, and he put his,
At the time of occurrence, he was, I think, 23 years. And the deceased was 19 years.
he was also time of occurrence. It
23
was
years.
also 23.
23
23 months, 23.
Besides,
And also, lordship, the conduct of the accused, lordship, he fought the case for 30 years, lordship. He did not abscond or run away, or stop coming to the court. That has also to be taken. For 30 years, a court case has been running, lordship.
What was happening? Nothing was happening. There was separation of judiciary. Matters was in limbo. Nothing was happening.
Still, lordship, 30 years,
Mhm.
it's not a.
He was a driver and by occupation driver.
Okay. We'll consider.
Lordship, if I may be given another date, lordship, just to present some precedents on ocular evidence, lordship.
No, concurrently just hearing. You can present it to our court master
Lordship,
or make a list and indicate the paragraphs.
lordship.
Why did you the other one, Sanjeev Mura, for what purpose?
It's lordship, it's for actually recording of oral evidence by police IO without the presence of doctor or magistrate.
Oral evidence, no, die declaration.
Dying declaration.
Which paragraph?
Paragraph, lordship.
That fitness of mind will come not.
No,
in
here,
case of
no, here it
oral.
is by the police. That we have not even,
Ah.
not
No,
even
paragraph-
These
considered.
are oral dying declaration. Here fitness of mind and all will not come. This
Paragraph
is when it is
19.
registered by magistrate or doctor.
Paragraph 19 and 20, lordship.
No, that declaration before the police, we are not even considering.
Lot.
Neither it has been considered.
Lordship.
This police, we are not even having him as a person before him dying. Dying declaration only before PW 1 and PW 4. Ke das, huh? Jahan, ABP, hearing conflict, judgment is affirmed.
Ultimately, lordship, this matter is a case of circumstantial evidence and no eyewitness, lordship. Corroboration is not up to date.
মই বনাই দিম কেনেকে দিব লাগিব নহ'লেও দিগদাৰি হৈ যাব